Mr. Anthony, can you hear me?
Yes, ma'am.
Okay. Have you spoken to a public defender since last week?
No, ma'am. Just that time where you set up the meeting. That was it.
Okay, well, we'll get you in the meeting room today because you should have spoken to someone again. And there was a public defender here last week that said they would take care of it. So that we can get you a new intake because you've been in custody. So I think you were previously denied. Because you didn't provide, it says you provide no contribution to the expenses and that you were living with a family member. Is that still accurate, sir?
Yes. And he also took information down because I've been unemployed, because I've been locked up. I haven't been able to make no cash. So that
Right,
was, I don't know.
that's why we requested another intake review.
Yes, ma'am.
So
Yes,
we'll
ma'am.
get-
Yes, ma'am.
I have Mr. Petrovich here, so after I handle his matter, what I'll do is I'll see if he can meet with you privately and do a new intake, okay?
Another intake?
Well, yeah, to make sure that they don't need any additional information so they can resubmit your application to the public defender.
Boy. Jesus Christ.
Mr. Petrovich, are you there?
I am.
Are you ready, Ms. Jackson?
I believe so, Your Honor.
Okay, Mr. Anthony, we're gonna put you in a meeting room and then I'll have Mr. Petrovich added there in just a moment, okay?
Okay.
Can you add him to a meeting room, please?
Yeah.
We're on the record in the matter of the people of the state of Michigan versus Negashay Jackson. File number is 22-00402FY. Can I have your appearance, please?
Yes, Your Honor. Charlie Petrovich, on behalf of Ms. Jackson, is appearing via Zoom from the Muskegon County Jail.
Today's the date that is set for sentencing on this matter. I think that this matter, we adjourned it so that we can allow you to have more time to find programming for her. I think that she was possibly eligible for some treatment at the Odyssey House in Saginaw, but we weren't, I think that wasn't confirmed. Do you have any additional information at this time, Mr. Petrovich?
At this time, effectively, I did, before this hearing, reach out to Odyssey House. They couldn't confirm or deny any statuses. They didn't have any releases for that information. In discussing the situation with Ms. Jackson this morning, she informs me that she effectively requested that CMH worker contact Odyssey House on her behalf and has heard no return information from that point. She's not been in contact with Odyssey House directly herself. So at this point, it does not seem that we have a confirmation that she's actually confirmed there, has a bed there.
Okay, so Odyssey House needs a release, which Ms. Jackson would need to sign. Is that what you're saying?
They would need that to communicate with me about anything for that. And it seems like she's not been in direct contact with them herself. So I don't know as though what their status is with her, whether the CMH worker, who's the only name I have is Emily, was able to actually start a process with them. So at this point, it's we can neither confirm or deny, which could mean they're 99% done. It could mean they've never heard of it. So I don't know.
Okay, and has she been screened for any other long-term inpatient treatment? Because I thought there was the potential of her being screened for other options.
Yes, for her communication with people she's working with in the Muskegon County Jail, she is eligible for those treatment programs. It's a matter of actually getting her into one when she's actually available for it. By way of update with her Muskegon County case, we thought she'd be sentenced there by today, but that sentencing was ultimately adjourned to the 14th due to the judge not being available on her original sentencing date. So the incarceration does make it difficult for her to navigate through that. I know through the Ingham County Jail, they allow for free calls to rehabilitation facilities and provide that contact information to inmates there. Ms. Jackson's informing me this morning that Muskegon County Jail has been refusing to allow her to make those calls herself.
Okay, and she's waiting to be sentenced at the circuit court in Muskegon?
It is the district court. It was originally the aggravated stalking, but it was ultimately reduced to misdemeanor standard stalking. So I believe it remained in the district court there. Oh, wait, no, it did get bound up. Sorry, that's my mistake. It did resolve in a misdemeanor, but it is the circuit court. That was a senior moment on my end.
Okay. Senior moment, you're not old enough to say that.
I try to avoid certain terms on it because when I'm being casual, I say brain fart. And this is the first time I've been able to say that on the record with a little bit of explanation.
I get it. Okay, well, I think originally the goal was to allow her to be screened. So I can have some further information about what programming she could be eligible for. And so I'm happy to know that she has at least been eligible for or screened to be eligible for treatment. We just don't know what treatment she would be going into. I also don't know what the goal of the circuit court in Muskegon is, as that's the more serious matter. I don't know if she's looking at probation at that court. I don't know if do you have a pre-sentence report that's recommending probation in that court?
She informs me that her attorney up there has told her that she is expecting to be released on the 14th, but I've not actually seen a pre-sentence report for that.
Okay. Okay. Well, I indicated before that I do believe that Ms. Jackson needs and would benefit from some extensive treatment. I think she requested the opportunity to undergo some treatment so that she can begin her work for a sober lifestyle. And so I can't order anything unless I have something that shows that she's been accepted into that. I can't order to go to any treatment facility. They have to show, or I have to provide information that she's been accepted there. And I know we're still waiting for information from the Odyssey House. The recommendation that was provided from probation was a term of incarceration for the safety of the community and the victim, and to have her screened to participate in some treatment, which we've had that done already, or at least it was done out of the Muskegon County Jail. Okay, so I don't know if you want to make any further allocation, but I'm inclined to move forward with my sentencing at this point versus putting it off any further for any further communication with Odyssey House, or to wait for sentencing in Muskegon County.
The only addition I would have is, I think, between the lines of what I've already said, which is that Ms. Jackson is trying her best to get into treatment programs. It's something where she has a lot of balls in the air right now that make it difficult for her. And she also has the matter up in Muskegon County. I do know that the report reflects that they're concerned with her past and returning to alcohol for that. But that's always going to be difficult for that. I don't think we should really give up on her. I don't think the full year would be necessary to get the impact of her behavior through to her on this. So I ask the court for leniency in this sentencing. Thank you.
Okay, thank you. leniency is not always in the best interest of the individual before the court. This is one of the largest criminal histories I've had at a time of sentencing. There's a lot of assaultive history here. And then she's currently before the court for a domestic violence second offense. And then also there was or is a case in which she's pending before the Muskegon County Court. And so the goal is not to just grant a lenient sentence, but the goal is to get her the help that she needs so that she can not return to court, because she has been stuck in a cycle here for quite some time. Her criminal history extends back into the early, well, actually extends even beyond this state, but back into the early 2000s. She needs some help. She requested some help by way of being ordered to do inpatient services. I don't believe that she is at the point where she could be of her own recognizance to make sure she reports to inpatient without the court providing a directive to do such. And so my sentence is going to be to make sure she gets that treatment and the services that she needed. I've adjourned this to allow you as her counsel to get some further work done to the extent that I could get information that shows that she's been accepted to inpatient, but I don't have that. And so because I don't have that, I don't have any other choice at this point but to order a term of jail time and to have her released only directly into inpatient services from the jail. Because if I release her with the expectation that she's going to do probation, she's not right now a good candidate for probation based on the illness that she is trying to overcome. So the sentence of the court will be 93 days Ingham County Jail, that she will be released directly and only directly into an intense or a long-term inpatient treatment facility. There will be no early release and no GPS tether granted while she's waiting for her release into inpatient treatment. Ms. Jackson is, I think, muted, but do you have any questions? If someone can unmute your device.
Yeah, I don't understand what you're saying, ma'am.
What I'm saying is that you need to go into some inpatient treatment.
Yes, ma'am.
And I adjourn this for a month so that I can get some information, so that your attorney and you can work on getting some information to me to show me that you are actually going to be admitted into the Odyssey house. I don't have that information.
Right.
I don't have any information saying that you've been approved to be admitted into any inpatient treatment. And so I'm going to sentence you to a term of jail time with the goal of having you held until you can go directly into the inpatient treatment.
But what was the 93 days?
That's the amount of time.
Sorry. The amount of time, but again, if you're getting, if you're going to be admitted for inpatient treatment, then that would be where you're spending your 93 days, ma'am, at the treatment facility.
But if I don't get into the treatment, I got to do 93 days in jail?
Well, according to your attorney, you've already been eligible for treatment or made eligible for treatment. So there should not be an issue with you going into treatment. And treatment, you should be your goal. Ma'am, because you're continuously committing the same actions, which are violent actions.
Yeah.
Which means there's a threat to the public. So you are not the victim here.
Right.
So the goal is to get you some help so you can stop victimizing others.
Yes, ma'am.
I can't force you into any treatment facility. I
Yes,
can only
ma'am.
request that you be screened for such, and that when is available, that you be sent over to long-term inpatient treatment. But I will
So-
not be releasing you to the public unless you have this issue addressed, because you are a threat to the public at this point without addressing the underlying illness.
So Ms. Simmons, what I'm saying is, if I can't get into a treatment, how many days am I looking at?
93 days is the order of the court.
Is the Odyssey House the only place that I have to look for?
No, Odyssey House is not the only place. There's other options, and my understanding from your attorney that you've been screened. So whatever,
Okay,
wherever they can get you in for treatment, you're free to go. I'm not saying that you have to go to Odyssey House.
okay.
Do you have any other questions, ma'am?
No, ma'am.
Okay, any additional matters for the record?
No, Your Honor, thank you.
So from here, so from Muskegon jail, I'll be transferred to Lansing.
Yeah, you'll come down to
I can't speak
Lansing.
that because I don't know what your sentence is gonna be over there. That's up to the judge. You may have a priority sentence over there for all I know. I don't know. But if you are released from the hold that they have when you in Muskegon County, then you would then be transported to Ingham County Jail for the sentence that I've ordered, okay?
And will I get any credit for the days that I've already done there?
Yes, you will get credit time served.
Okay.
You have any other questions, ma'am?
No, ma'am, I thank you.
You're welcome and good luck.
All right, thank you. Have a blessed day.
Same to you. Thank
All
you.
right,
Mr.
bye-bye.
Petrovich, can I put you in the meeting room with Mr. Anthony?
Over to him.
It's Charles Anthony, I believe, or Carlos Anthony.
Is he in room 1?
He's in room 2. Did you put him in?
Okay.
We'll move you to room 2. I didn't go out the judgment of sentence. Okay, he's taking care of Anthony. Who do you have, Mr. Ferguson?
I have one Bashkeen on it. We're gonna play on one of the three files. I think he's here on it.
He's here.
That's downstairs.
Okay, did you? I'm gonna bring him up.
We also have a pending PA 53 that we put.
Okay, we'll have him brought up. Who do you have?
I have Bryce Taylor. He was taken off the docket for today, some mistake on, or say our part for last week. He got issued a warrant for failure to appear for probable cause conference. And he did.
We held it over email. I didn't hold it. So that's why.
We didn't know about the warrant until today, so.
Oh, there is a warrant.
Yeah.
Yeah.
Okay, Big O, you get grab the file. for
They're
me?
both right here, same thing, same happened.
I have another, there's
Mr.
no,
White.
same thing happened.
Okay, so in the past, what the prosecutors that have been before the court has done is sent the emails with the offers to the public defender or the attorney and CC my staff. And that way we know when there's a response. But we also know when there was an offer so that we know that the PCC has been handled. So we don't end up with issues like this. I'm gonna quash both bench warrants though.
I apologize, Your Honor. Usually I'm very good at sending them, but I don't know what happened last week. I don't know if it was a double doc or not, but I missed both of them.
Okay. Okay, was it, he has one file?
Yes, Bryce Taylor.
Okay, was Mr. Bites the same thing? Is that
Yeah,
what it is?
same
Okay.
issue. I mean, it's my understanding, Judge, that they both wanted to hold their exams, so.
Okay. Let's bring your client up. Sir, what is your name?
Just.
Last name or your Phillips?
Mike.
Is-
The one they were just talking about.
Yeah, he's the.
Oh,
one
Mr.
with the- Yeah.
Mr. Bites, okay, we're gonna have. You have your witnesses on both of those?
I do not have them here today because it was moved in the docket.
Okay. Okay, we're on the record in the matter of the people of this state of Michigan versus Jason Bike, file number 22-01157. FY, council appearance.
Morning, Your Honor, Andrea Lacey appearing on behalf of the people.
Jason Martin.
Oh, this attorney's not here, is that what's?
Mr. Austin is his attorney. He
Almost
is
you.
in the building. right?
Oh, okay. I thought Ms. Donnelly was your attorney, but she's not.
Just Mr. Taylor's.
Oh.
Yes.
Your Honor, I don't know where he's at.
Sounds good. So Ms. Donnelly, you're appearing on his behalf for the limited purposes of addressing the timeline on this.
Yes, Your Honor, thank you.
Okay, thank you. Today was the date, sir, that was originally set or reset, I should say. No, it was originally set for your preliminary examination due to some miscommunication between the public defender's office and the prosecutor's office. The court was not made aware that your probable cause conference was handled. And so when you did not appear, a bench warrant was issued. We've now been made aware of that. So I'm going to quash the bench warrant. And you wish to continue to your examination. That's correct, sir? No, you were correct. That information was never communicated to the court. So when we were waiting for you to appear, because we didn't know that you had already been handled, that's how a bench warrant got issued. But it was already addressed. So, but the unfortunate issue is that now there's no witnesses here because it was removed from the docket because there was a bench warrant in place. So what I'm going to do is based on that, I'm going to find good cause to waive the 21-day timeline because you do have the right to have your exam within 21 days of your arraignment. So your exam would have been today. But because of the miscommunication, the court's going to waive the 21-day timeline. I'm going to get you a new date as early as possible so that we can hold your examination, okay? June 17th at 9:30. We're going to give you a copy of notice right now, okay?
Yes.
If you have any questions today, sir? Any additional matters for the record?
No, Your Honor, and I apologize again.
Oh, no problem. Errors happen. You have a seat there, sir, unless you have a question for me, and we'll get you a copy of your notice, okay? Thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Bryce James Taylor, file number 22-01131 FY, council appearance.
Good morning, Your Honor, Andrea Lacey appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Bryce Taylor, who is standing to my right.
Why didn't we have a shirt? They didn't provide him with a shirt?
This is how you can.
Okay. Okay, Mr. Taylor, how are you? Good. Okay, today was the date that was originally scheduled for your preliminary examination, similar to the last case. It sounds like there was a probable cause conference conducted via email. That information was not provided to the court. And so when you did not appear last week, which you shouldn't have because your stuff was taken care of, the court issued a bench warrant. We're going to quash the bench warrant at this time, but because of that miscommunication, there are no witnesses here to proceed at this time. I'm going to reset this matter so that you can have your examination, but you did have the right to have your examination within 21 days of your arraignment day, which is why it was set for today. Due to the miscommunication, the court's finding good cause to waive the 21-day timeline and get you a new court date, okay?
Thank you.
Do you have any questions?
No.
Yes.
Why?
Who did that? Except for sentencing, I think that's an error. Oh, he thought it was gonna be a plea, that's why.
Okay, I was just, okay,
Okay, we can remove that.
June 17th.
June
At 9
17th
a.m.
at 9? At 9 a.m., okay? Do you have any questions, sir? Any additional matters for the record?
Your Honor, I just want to place the offer on the record. There was an offer extended to Mr. Taylor to plead guilty to the original count 2. In exchange for that, we would dismiss the original count 1. Miss Donnelly did email me about HIDA. I don't believe I ever emailed her back about HIDA. I would have no objection to HIDA at this time, but that offer will expire at the time of PCC.
Oh, very good. I'll note that here in the file. You understand the offer there, sir?
Yes, Your Honor.
Okay, so you have time to think about it and your attorney can advise you on it and you'll let us know before your court or your hearing starts, okay?
Yes, Your Honor.
Okay, any additional matters?
No, Your Honor.
No, thank you.
We'll get you a copy of your notice, sir. Thank you.
Yeah, well, at different times, it was at 9.
Okay, that's fine. As long as the date.
Um, Your J1 Bastion. We're on the record in the matters of the people of the state of Michigan versus J1 Bastion, file numbers 21-01310 FY, 22-00059 FY, 22-01067 FY. Council appearances.
Morning, Your Honor. Andrew Lacy is hearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Bastian, standing to my right, Your Honor.
Okay. Mr. Bastion, today's the date that's set for 3 preliminary examinations and 3 PA 53 contempt violations here. Okay, so I have here a report from the Lansing Township Police, a date of May 31st, 2022, about 9:47 p.m. And the allegation is that you had some contact with the police during that time, and that the conditional release from this court required that you be wearing a GPS tether. The allegation is that you violated that condition of your bond. So you have the right to have a contested hearing. You have the right to be represented by counsel during that hearing. If you're found to be in contempt of the court at the time of that hearing, or if you plead guilty, you're subject to the penalties in the amount of 93 days Ingham County Jail or a fine in the amount of $7,500. Do you understand that? I just want to make sure these are all the same. Okay, so I want to clarify, you are on GPS tether, correct? Or you were at the time? Okay, so I think the allegation is that, are you being charged with a new offense? Is that what the allegation is?
A little bit of both, Your Honor. I think there is a new charge pending with the district court, but I also think there was an allegation of contacting the alleged victim.
I don't know if I see that in this report. Okay. Okay, there's a sense of another party allegedly was in the vehicle, Selena Isabel Rodriguez. And there is a no contact order on each of these files. So today I have here that there was an offer for the defendant to plead guilty to 2 counts of domestic violence dismissed count or cases 21-01310 FY and 22-00059 FY. However, I'm going to address this PA 53 before I entertain any plea offer. I don't know if you had an opportunity to discuss that with him already.
I did, Your Honor. I believe that we are under the anticipation of making an admission this morning on that.
Okay. Okay, that's correct, sir. You want to admit to the violations of the court's conditional release from custody? Sir, can you raise your right hand if you can? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay. So I've explained to you, sir, that you do have the right to have a contested hearing today on this matter as about the bond violations. You have the right to be represented by counsel. You do have your attorney here with you. And so if you want to have a hearing, we can set it for a hearing. Do you want to waive that hearing today?
You said for the bond?
For the bond violation, the allegation that you was having contact with the victim in the underlying matter, and that you, I think, picked up a potential new case on May 31st. You want to waive a hearing on that and admit to it, or do you want to have a hearing? Or do you want to stand mute?
Like admit to it, yeah, I did it.
That's what an admission would be.
Okay. Well, yeah.
Okay. Is anybody forcing you to do that, sir? Has anybody made any promises to you to get you to waive your hearing and admit to the violation?
Ma'am.
Okay. Okay, and so you were placed on a bond in each of these files during the arraignments. If I can find the bond sheet. I don't see the bond sheet. This looks like it's Magistrate Faulkner's handwriting. Yes. Okay, so you were placed on bond 25,000 cash surety in this file 22-01067 back on April 23rd, I believe, Magistrate Faulkner, April 24th. And one of those conditions, sir, was that you would be on GPS tether, but that you were not to be within 1,500 feet of a Selena Rodriguez, that you were not to have communication directly or indirectly with Selena Rodriguez. Is that correct? Okay. And on May 31st, 2022, did you violate that order? Okay. How did you violate that order?
I was where when they were about to get pulled over. And
Your Honor, I want
She was
to,
in the car with
I
you?
want to stop something quick because I don't want to make admissions in regards to a pending criminal case. Because I have no issue.
Okay. That's fine. She was in the car with you? I need you to say it out loud.
Yes, ma'am.
Okay, you knew that it was in violation of your bond?
Yes, ma'am.
Okay. Any additional factual basis?
No, Your Honor.
No, Your Honor.
Okay, the court is satisfied with the factual basis. I'll accept your admission to the bond violation. I now ask to the plea. Here, there's an offer again for you to plead guilty to counts or to 2 counts of domestic violence. Which files is it gonna be on?
22-1067, Your Honor.
Okay. And the other cases will be dismissed. Is that what you want to do today, sir?
Yes, ma'am.
Okay. And you've already been waived in, to tell the truth, under penalty of perjury. Sir, you have the right to have a trial in this matter. You have the right to have a jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to remain silent at trial and not have silence be used to prove or implicate your guilt. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecution prove each element of the charge being brought against you beyond. They have to prove each element beyond a reasonable doubt. Do you understand those rights?
Yes, ma'am.
If you want to plead guilty, you have to give up those rights today. Is that what you want to do?
Yes, ma'am.
Okay, is anybody threatening you to waive your rights and plead guilty to these 2 counts of domestic violence?
No, ma'am.
Is anybody promising you anything to get you to plead guilty? Okay, are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
You understand that a guilty plea can result in a conviction that you may need to report to your current job?
Yes, ma'am.
Okay, you may also need to report a conviction to future jobs.
Yes, ma'am.
Okay, and you understand that a guilty plea can result in a conviction that may impact any immigration status you're seeking. Is this your signature here, sir?
Yes, ma'am.
Did you read this? Is that a yes?
Yes, ma'am.
You understand the rights there?
Yes,
Do you
ma'am.
have any questions about this document here? As to count 1. I'm sorry, it says it's gonna plead to 2 counts of domestic
It
violence.
would be the original count 2 and then the added count 3, Your Honor. I apologize for the way that the plea form is written.
Thank you. As to count 2 of domestic violence, how do you plead?
Guilty.
As to the added count 3 of domestic violence, how do you plead?
Guilty.
Can I have a factual basis, please?
Yes, Your Honor. Mr. Bastian, let's hear intention back to April 23rd of this year. Were you living on 4062 Woodbridge Street?
Yes, sir.
That's here in Lansing,
Mhm.
Lincoln County,
Is that a
State of Michigan.
yes?
Yeah, yes.
Ingham County, state of Michigan. Is that correct?
Yeah,
And when you were
Yes.
living there, you were living with a Selena Rodriguez, is that correct?
yes, sir.
That happens to be not only your girlfriend, but the mother of your child, is that correct?
Yes, sir.
And you and Miss Rodriguez got into an argument, is that correct?
Yes,
And during that argument, you assaulted Miss Rodriguez, is that correct?
yes, sir.
And you were the aggressor in that argument, is that correct?
Yes,
And you pushed her, is that correct?
yes, sir.
And you did that twice, is that correct?
Yes, sir.
I have no additional questions today.
Any questions from you, Ms. Lacy?
No, Your Honor, I believe that's sufficient for the factual basis for two counts of easy.
We're satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. These and the other two files and will be dismissed. File number 21-01310 and file number 22-00059 are dismissed for the plea agreement. The sentencing dates July 15th, 2022 at 8:30 in the morning. Prior to sentencing, you're going to meet with probation so they can provide the court with a pre-sentence report and investigation with a recommendation as to how you should be sentenced, okay?
Yes.
Okay, do you have any questions? Any additional matters for the record?
Just Your Honor, I may have mentioned it, but I just wanted to reiterate for the record that the people have no objection to Mr. Bashan being sentenced under the 7694A statute if he is eligible. We would also, we've also extended a Killaboo offer of no upfront jail at the time. And then I had extensive, an extensive conversation with the victim, Selena Rodriguez, who is present in the courtroom right now. After that conversation, I had previously let Mr. Feigelson know that if he had requested tether removal, I would not object to that. And also, at the time of sentencing, if he were to ask for the bond to be amended to include no assaults of contact, so they can have contact with their kids. My understanding that they're their own family, like they don't have additional family outside of their home. I would have no objection to that based on the conversations I've had with her.
Okay, yeah, the form does say that there is a request for 769.48A, so
Yeah.
they will advise if he's eligible at the time of the pre-sentence report. As to the Killaboo agreement, that's an agreement between you and the prosecutor. I'm not a participant in that agreement, okay? So if I decide I'm gonna order you to do upfront jail, I'll let you have the opportunity to withdraw your plea at that time, okay? Let's see. Also address sentencing on the bond violation all at the same time.
That's perfect.
Okay, was there a bond motion?
There was, Your Honor, given what Miss Lacy has said, I was gonna ask for two things. One, Mr. Bashan does have his GPS tether on. I asked that if you remove, Your Honor, Ms. Rodriguez has indicated she does wish to have contact with the both or only the only support system here in the area, Your Honor. And also, I know the prosecutor wants it at sense, but ask for the no contact order to be lifted today, Your Honor, have them work through the issue with their child, and if they're willing to have civil conversation, I think if they can, Your Honor, I ask that this be lifted today.
Looks like. Ms. Rodriguez is here.
Yes,
Yeah,
sir,
right.
she is.
Who's Ms. Rodriguez? You're Ms. Rodriguez? I can't hear you. Okay, okay. And you want the no contact order lifted? Okay, and why is that?
That's all I got. We had, you know, everybody, young, you know, so everybody made a mistake, but I mean, that's all we got. We got him. I can't go around him without him getting in trouble. I want him to go through. Just like this, I can't. That's him.
Okay, and I recognize that you clearly love him, that, I recognize that, but the concern is safety. Okay, you feel that your safety is not at risk? Okay, because this was an assaultive crime that he's pleading to. I mean, you're the victim. There was a no contact order, which he just pled to violating, and doesn't sound like he was holding you at gunpoint to be there. You wanted to be there? Okay. I'm going to remove the GPS tether. I have concerns about both of you. And I recognize that you probably have limited family resources, and I don't discount that you love him. But there were just before the court 3 different files for assaultive actions, and you were the victim in all of them. So I still believe your safety is at risk. Because although that may be all that you have and that you may have love, when there's an issue and families have issues, there's a concern about how those issues are being addressed. So that's the concern. I'm going to grant the request for you to have communication for the purposes of childcare. That's all I'm granting the request for at this time. I'm not removing the no contact order at this time, okay? Because again, I just had 3 different cases where you were the victim, and 2 pleas to assaultive actions before me. And so I need to get some more information before I can remove the no contact order comfortably, okay? But as I will amend the no contact order so that you can have a peaceful contact communication about your children and their welfare, okay?
So as far as that, if I go around him, if he comes around me for kids, he won't be in trouble or locked up.
Well, I'm assuming you have to exchange children, or is that the case? You have children that, my understanding is there was an order before that someone else had to exchange the children between the 2 of you or transport the children between the 2 of you. I'm not requiring that. You can have communication or interactions for the purposes of childcare. Okay? Any other questions? Okay. Oh, you're fine. Do you have any questions about that, sir? That's a no. She has to be able to hear it. Thank you. Thank you. Any additional matters for the record?
None, Your Honor, thank you.
Thank you. You're all set.
Thank you, Your Honor. Have a good day.
You too. Is there someone in the jail for me?
Yeah.
Okay. We're on the record, Ms. Lacy, I see you. In the matter of the people of the state of Michigan versus Carlos Anthony, file number 21-01700, council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
I will state I am a Charlie Petrovich, but I'm appearing on behalf of my office at this point because we've not been fully appointed, but I am prepared to speak for a limited appearance for Mr. Anthony this morning.
Thank you. Today was the date that was set for preliminary examination. Mr. Anthony was before the court last week I advised him that he had been denied court-appointed counsel. We have a letter signed by the public defender dated for May 17, 2022, indicating that the information he provided didn't show that he made any contributions to household expenses, and so that's why he was denied. He indicated to the court that he had been in custody for some time and therefore unable to work, which makes his income zero at this time. I requested the public defender's office to resubmit his information. He's before the court today. My understanding that he had not had any additional communication with the public defender's office. Mr. Petrovich, you were nice enough to meet with him today, although you were present on another matter to do or to get some information. And did you have something to share with the court?
Yes, Your Honor, I do have his information. I'm not sure what happened following the PCC date, because the last note we had in the file was support staff attempting to reach Mr. Anthony while he's apparently incarcerated, sending him a letter trying to call him when they're unable to do so. So I have gotten all the information for that application. He should be presumed eligible for public defender due to his incarceration status. He's been in the Eaton County Jail since April 9th and does not believe he's going to be released within the near future. And that is something that's going to have a significant effect on that. I would ask of the court, if the court recalls, who indicated at the last court date that they would rescreen him, because as I said, there's nothing on the file, and I'd like to know who was contacted about that. So effectively, I can go have a stern talk with them.
I would have to pull up the record because I don't have a note here as to which public defender it was by name. So I would have to pull up the record to find out who it was. But as typical, I try to, whoever's in the courtroom at the time they're it. So.
Oh yeah, no, I'm very much aware of that right now.
Yeah, so we can try to get these issues resolved. So because of the fact that there's been no public defender appointed at this time, Mr. Anthony, I am going to find good cause to waive the 21-day timeline. Because you had a right to have your examination within 21 days of your arraignment. You were arraigned on this matter, looks like on May 16th. So I'm going to waive the timeline only to extend it so that you can get a new date and have the benefit of representation by the public defender's office. And you said he's obviously being held on something else because he has a PR bond on this, correct?
Correct. He's held in the Eaton County Jail, and yeah, so that is what's holding him in custody.
I did a PCC when? June 16 and 9. And then the exam date, June 24th at 9:30.
Okay, so we're gonna reset his probable cause conference for June 16th at 9 o'clock in the morning. A new preliminary examination will be June 24th at 9:30 in the morning.
Excuse me, Your Honor.
Yeah.
Excuse me, Your Honor. I have a court date in Eaton County on that date, ma'am. At 9:30, I think it's at 9:32.
No, which date is it that you're talking about?
Yes, ma'am. Yes, ma'am. June 16th at 9:30, I have court at Eaton County.
Okay.
Yes, ma'am.
Okay. Well,
Just to make you aware.
PCC, you don't necessarily need to be here in person for it. I can move it later because if your attorney contacts you and there's an offer and you want to either accept or continue, they can just notice the court. You don't actually need to be present for the PCC. But what I'll do is I'll move it later in the day so that if you do have a court date Do you know what the nature of the other court date is? Is it a hearing or like a trial?
No. This is like, it's a prelim.
Okay.
No, it's been
So I'll
waived
move
over.
it
so
later
this-
in the day.
Okay. Thank you.
We do that in the afternoon. I'm gonna move it to 1:30. Okay?
Thank you.
No problem. And then 24th at 9:30 will be your exam. Any additional
All
matters
right.
for the record?
No, I'm good.
Nothing for the future.
Not for me, Your Honor.
Okay, thank you, Mr. Petrovich, for your help.
You're welcome. Glad to be here.
Thank you. Thank you, Mr. Anthony. You're all set.
Thank you. Have a good day.
You too. Mr. Abbott, I see you over in the corner.
Lurking.
Oh, okay. I thought you had something for me.
We do, we got 2 cases.
I'm just gonna check everything around.
Okay, sounds good.
Got Barbie and Lindsay and Cooper.
Well, you have all 3 of those? That's not good. Got timeline today, Miss Sue. Have it.
Wanted to,
the record in the matter of the people of the state of Michigan versus Jakai Daquan Lindsay, file number 22-01299. Council appearance, please.
Good morning, Your Honor. Andrea Lacy, appearing.
Morning, Your Honor. John Abbott from the Ingham County Public Defender's Office representing Mr. Lindsay. He is present and he's standing to my right.
Thank you. Today's the date that was set for preliminary examination. Council, are you ready to proceed?
Your Honor, unfortunately, both of the officers who were subpoenaed to be here today are not present. So you are unable to proceed at this time.
Move to dismiss, Your Honor.
The motion to dismiss will be granted without prejudice. That simply means, sir, that it's going to be dismissed today. The people do have the right to reissue the charge at a future date. If they do that, you'll have to postpone and everything all over again, be rearranged. But as of today, the case is dismissed, okay?
Okay.
Do you have any questions? If you have a seat, we'll get you a copy of your dismissal, okay? Okay, we're on the record in the matter of the people of the state of Michigan versus Andrew Harvey, file number 22-01287 FY. Council appearance, please.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Harvey's president seated to my right.
Today was the date that was set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
No, Your Honor.
None for the defense.
Thank you. You can call your first witness.
Your Honor, for their first witness, we will call to the stand Officer Donovan Moore.
Do you solemnly swear or affirm the testimony you're going to give is truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. Please state your first name and your last name and spell them both.
First name is Donovan, Donovan. Last name is Moore, Moor.
You can proceed, counsel.
Thank you. Can you please state your occupation for the record?
I'm a police officer for the city of Lansing.
And how long have you been employed by the city of Lansing?
3 years.
Okay, and I'm gonna take you back to May 15th, 2022. Were you working in your capacity as a police officer on that date?
Yes.
And were you working for Lansing on that
Yes.
date? Okay, do you remember if you're working alone or with a partner?
We're with a partner,
What's your partner's name?
Officer Simmons.
And just for the record, Your Honor, that's spelled S-A-L-I-N-A-Z. Is that correct, Officer Moore?
Yes.
Okay, thank you. And were you in a fully marked car on that date?
Yes.
And how were you dressed?
Fully dressed, says police in the back.
Okay, and on that date, were you present at in the area of 540 West Willow, apartment B12 in the city of Lansing in Ingham County?
Yes.
And what's located at that address?
It's an apartment building.
Okay, and what prompted you to go to that location?
Someone called the police saying that she was assaulted and that she was gonna be waiting for me over at the residing apartments parallel to the address.
Okay, and when you got to that location, what did you observe?
I observed a female, she identified herself as Letitia Lewis. She advised that her ex-boyfriend, male named Andrew Harvey, arrived in a red Charger at her apartment complex, assaulted her. And when I first made contact with her, I observed a large bruise on her underneath her right eye. And she was also getting text messages from a female inside that apartment saying that Mr. Harvey was.
Objection, Your Honor. You're saying.
Okay, we don't need to go into this.
Objection sustained.
Thank you. And she did give you the name of Mr. Harvey, is that correct?
Yes,
And she identified him as her boyfriend,
ex-boyfriend.
ex-boyfriend? And, Your Honor, I believe that is sufficient for the foundation for the statements that Ms. Lewis made to come in under MCL 768.27C.
Any objection?
Your Honor, I'd ask the court to withhold the judgment on whether to apply 728. You know,
768.27C. I get it.
We're laughing.
Sorry.
Well,
I don't know either, so.
just because there are other factors that need to be considered in terms of the reliability of the facts and circumstances surrounding the statements made, I ask the court to withhold judgment on the applying that stage.
Okay, very good. You
Thank
can
you.
proceed at this time.
Thank you. I'm gonna show what's been marked as people's proposed exhibits 2, 3, 4, and 5 to defense counsel. Okay, perfect. There's no approach to witness, Your Honor.
You may.
Officer Moore, without telling us anything about those photographs, will you please just look at them and tell me if you recognize them?
I do recognize them.
How do you recognize them?
The victim who called the police.
Okay, and that's the victim that you've identified as Letitia Lewis, is that correct?
Yes,
Okay, and did you take those photographs?
I did, yes.
Okay, and are any of her injuries depicted in those photographs?
Yes, they are.
Okay.
we'll go through those in a second, but would you say that that's a fair and accurate representation of what she looks like when you spoke to her that night?
Yes.
Okay, Your Honor, I'd ask that those be admitted as people's exhibits 2 through 5.
Any objection? Okay, they are admitted.
Officer Moore, will you, if there's a picture in there that depicts an injury, will you please tell us what exhibit number it is and what the injury that is depicted?
So it's gonna be 2 different injuries on exhibit number 4. The top picture shows on the right side of the neck. Small 2 scratches I observed. I took a picture of that. And then these scratches are red and they're approximately an inch long. And then the picture below that is the victim underneath the right eye. You can see redness and bruising. It's swollen up to the size of what I believe to be a golf ball size.
Okay. And are there any other injuries specified by any of those other exhibits? Okay, Your Honor, I ask that furnish the report.
Okay.
Officer Moore, did Ms. Lewis describe to you an incident that occurred between her and Mr. Harvey?
Yes.
And based on your training and experience as an officer, the injuries that you observed consistent with what she was telling you?
Yes.
Okay. And can you also tell us what her demeanor was like on that date?
She kept using terms about being afraid of the past and telling about how she was assaulted by Mr. Harvey in the past, and specifically how she was choked in the past by him, and how whenever during this incident, how she would just react and almost be afraid of Mr. Harvey didn't want to get assaulted. She expressed her
Very fearful of him.
yes.
Okay. Now, Your Honor, I believe that would establish the additional Mr. Abbott was discussing previously. I asked that her statements be allowed to come in under MCL 768.27C.
Are you continuing your objection?
Yes.
The objection is overruled. You can proceed.
Thank you. Officer Moore, can you tell us what it was that Ms. Lewis described to you that happened that night?
Yeah, so Mr. Harvey came over to Ms. Lewis's apartment. There's a rumor about Lewis possibly seeing another male, and so Harvey got upset. Lewis told me that Harvey said wanted to kill her and approached her. And at that time, Lewis said that she just reacted and just pushed him away, pushed Harvey away. She tried to leave, and then Harvey again approached Lewis, and she remembered the times in the past that she was choked Harvey and tried to push him away again. That time, the second time trying to push Harvey away was unsuccessful. And at that time, Harvey grabbed Lewis by her collar and began to shake her back and forth for approximately about a minute long. During that time, she said she was afraid that she was going to get assaulted again.
Okay.
And so she tried to push Harvey's face away, and this was unsuccessful. And Harvey began to punch Lewis and that face. She was able to put her hands up and block her face and protect her. At that time, she moved her head out from her arms out of protection, and she got punched to the point so hard in the face to the point where she fell.
Okay. Let me ask you real quick. Did she mention when he had grabbed her by the collar, was she able to breathe at that point?
Yes.
Okay. And then at this point, he's on the ground. Is that correct?
Yes.
Okay. And what did she say happened after she was on the ground?
After she was on the ground, she said she had to bring her arms up and protect her head because Harvey was again punching her and kicking her and saying that she said that Harvey said that I'm gonna fucking kill you, give me my money. And from that point, she said she was afraid. She made a point throughout my interview that she got knocked out, and which would make sense to me just based off the injuries, a very huge and swollen bruise on her right side of the face. And she first told me that she got knocked out when she was initially punched. She and Harvey was shaking her back and forth. Then she was saying she got knocked down when she was on the ground after she got punched in. To me, it seems like she was confusing where she got knocked down.
Speculating.
Should I respond to the objection?
Your Honor, he is just, I didn't hear anything that called for speculation. It does seem like he is telling her, or telling what she told him. So I don't know if she's speculating or not. I don't know where that particular part comes in, but it does sound like he's describing what was told to him, to me.
Mr.
Mr. Honor, the sentence started with the phrase, "It seems to me that," and he, I don't know, to me like he was going to express an explanation of why she was changing her story.
Okay.
Which was
Well, that's fair, but I do think that he was going, in fact, I actually think it was going to be his own kind of sense of passion of what she was telling, because I do remember hearing the word confused as well.
Okay, because it was in the beginning of the statement, I don't know what it was gonna precede that. I'm gonna allow him to tell his statement and then I'll make a ruling on the objection.
Thank you.
You can restate the question.
You were, I was asking what happened after she was on the ground. You had described about her being knocked out twice, and then you said,
Yes, so she was saying that she was first knocked out, she was initially punched, and she was saying she got knocked out the second time when she was assaulted on the ground. And she was confused about it,
Okay.
about where she was knocked out. But the facts of where everything else before and after the fact, she got knocked out were the same. It just seemed what she was saying and how her confusion was makes sense. She was knocked out.
okay, so
Okay, as to the objection, so it was about the confusion, is that what he was, okay, the objection's overruled.
So let me just make sure we're all clear. She appeared confused to you, correct?
Yes.
Okay. And was she, when you say knocked out, did you understand, what did you understand her to mean?
She was saying that she was on the ground, her hands above her head, and then she almost like came to, but that's why it made you think that she was not
Okay, so unconscious?
unconscious.
Okay.
Yes.
And do you believe that she had been knocked out or unconscious one time or two times?
One.
One time, okay. But she was confused about when it happened.
Yes.
Okay, okay, thank you for clarifying. And based on your training and experience as an officer, would the confusion be consistent with her actually having been knocked out or unconscious?
Yes.
Okay, thank you. And then what happened after she came to?
So she said, Lewis said that she was able to get up, and after she was getting partially picked, get up away from Harvey, sarcastically asked, "Did you just punch me?" And she grabbed a metal pole and began hitting the TV and yelling. During this time, she told me that she didn't hit Harvey at all with the pole. And, after that, Harvey grabbed the pole away, threw it away from Lewis, and Lewis turned around and started walking away to leave the room.
Okay, so she was trying to leave. And what happened when she tried to leave?
Harvey came towards Lewis, put two hands around Lewis's neck, and began to squeeze for approximately 2-3 minutes. And then during this time, Harvey was pinning Lewis against the wall. Lewis advised me that she didn't lose consciousness at all, but she had a hard time breathing to the point where she was gasping for air.
Okay. And did she indicate approximately how long it was that Mr. Harvey had his hands around her neck?
It's approximately 3 minutes.
Okay, and was there anything else after that happened that she described to you?
Then she advised that one of her children came inside the room and saw it happen, saw her being choked, and Lewis told the child to get out of the room and just go away.
Okay. And what happened? Did anything happen after you were talking to Miss Lewis?
Yes, I called for medics to come in because obviously I thought she was going through something very traumatic, and I think that she needed some medical services.
Okay.
So I called medics there, and after that, she was great. She didn't want to go to spare.
Okay. And what happened? Did anything else happen?
I interviewed with one of the witnesses that was inside there.
Okay. And at some point, were you able to make contact with the defendant?
Yes, yes.
How did you make contact with the defendant?
So when I first arrived on the scene, she was in Walnut Park Apartments, not the Little Vista Apartments. I was trying to get some basic information about what happened after making out the conviction. She had a bruise on her right eye, major right eye. And she pointed across the street after giving me a name of Andrew Hardy. Pointed across the street, like, hey, he's in that red Challenger right there.
Okay.
And I turned around and I observed a red Challenger leaving the Little Vista Apartments and shooting southbound.
Okay. What did you do when you saw that vehicle?
Ran back to my patrol car. I didn't know if he was trying to leave or anything like that, or just trying to escape. So I ran back to the patrol car, attempted to initiate a traffic stop. And at that time, we were going eastbound on West Saginaw from Pine. Speed. I was attempting to catch up to him, but I was also pacing at that time. That was approximately 55 miles per hour. It's a 35 mile per hour zone. And around Saginaw Center is when I was able to effectively initiate a traffic stop.
Okay, so you were able to effectuate a traffic stop, is that correct?
Yes.
Okay. And when you initially made contact with Ms. Lewis, she gave you his name, correct?
Yes.
Did she also give you a physical description?
A black male.
Okay. Did she give you anything, any specific features that he had?
There's a large male with large hands.
So just a large male or large black male with large hands, but you did point out the specific vehicle, correct?
Yes.
Okay. And when you effected that traffic stop, you able to make contact with the people inside the vehicle?
Yes, there was one person who was in the driver's seat. Advised, I asked him, hey, are you Andrew Hardy? Advised he was, and I told him that I was investigating a possible domestic involvement with that stroke.
Okay. And the person that you have identified as Mr. Harvey, is he present in the courtroom right now?
Yes.
Okay. And can you please point to who describe who wearing for the court?
Yes, black male, bald, with a beard, with a blue mask and a red long suit.
Thank you, Your Honor. Please let the record reflect the witness has identified the defendant in this matter.
Any objections? I do.
Jeff, Your Honor, he's wearing a mask. How can you tell who it is?
Well, the facial features are not what involved, very similar to everything I saw.
Would it be helpful if we were to remove this mask?
Yes.
Your Honor, please ask that you instruct the defendant to remove this mask.
Yes.
Further objection?
No.
Okay, identification is noted.
And based on the interaction you had, well, let me ask you this. When you stopped the vehicle, did you run a lean check on the plate at all, if you remember?
Dispatch does that automatically.
Okay.
I didn't personally do that.
Okay. Do you know if dispatch did that on that time?
Yes.
And did you get that information from dispatch with regards to the owner of that vehicle?
Yes.
And do you remember if it came back registered to Andrew Harvey as
Yes.
well? Just one second. Officer Moore, did you talk to Mr. Harvey at that traffic stop?
Yes.
Okay, and did he indicate to you whether or not he had been present during this altercation?
Said he was present and everything that happened was purely verbal altercation, nothing was physical.
During your investigation of Miss Lewis, did you ask her about those injuries that you observed on her?
Yes.
And did you ask her if they were present prior to this altercation?
I did not ask them.
Okay. Did she indicate in any way that they were present prior to the altercation?
No, when she said she got punched, she pointed directly at these areas and she said, when she was saying that, when she was talking about the incident and saying when she got getting injured, she was pointing to the areas that I saw the marks at.
Okay, so they were consistent with the statement she was making?
Yes.
Okay. And those marks looked fresh to you?
Yes.
Okay. Was there anything else that she indicated to you, but perhaps some property of hers that was damaged?
Yeah, so I went back up to the apartment afterwards, regarding possible damage to the property. I made contact with someone who's in the apartment, and she was telling me that.
Well, let's not talk about what she told you. But were you made aware of things that were damaged?
Yes,
And was it alleged that Mr. Harvey had damaged those items as well?
yes,
And did those items belong to Miss Lewis?
yes.
Okay. And do you remember what those items were?
It was a tan couch and blue jeans.
And I'm showing what the Martha's People's Proposed Exhibit 1. Officer Morgan, just let us know if you recognize the photograph.
Yes, I do recognize it.
Okay. And are those the items that you believe Mr. Harvey had done some damage to?
Yes,
And the blue jeans and the couch depicted in those photographs, correct?
correct.
Now, did Miss Lewis tell you about those items?
No,
Okay, is that independent witness?
yes,
But you did observe them in Miss Lewis's apartment?
yes.
Okay. And I asked that this be admitted as people's exhibit number 1.
No objection.
People's Exhibit 1 in here.
And I have no further questions.
Okay, I just have a quick question. Please just show me where the damage is on here.
So back here, it's all cut up. You can see
Oh,
the
sliced.
clearest one. Yes,
Okay.
slice. And right here, like,
Okay. Okay, thank you. Proceed, counsel.
Thank you. Good morning, Officer Moore. You didn't see who did the damage to the couch of the blue jeans?
no, I did not.
And you didn't see how she actually sustained the injuries?
No, I did not.
And you don't know exactly when she sustained the injuries?
I interviewed my victim. She told me that.
That's what she told you, but you didn't yourself know exactly when you did it?
No.
Based on your own observations?
No.
Did you tell if she had been drinking or anything?
No,
And you noticed, and you mentioned that she kept referring to the past assaults. Had been assaulted in the past.
yes.
You also mentioned that she was confused about the sequence of events.
One specific. She got knocked out. Nothing else.
How could you tell how the extent of her confusion?
By the way, her story was uninterrupted in the beginning of the event when she first made contact with Harvey. And then after she was got up from the ground, she was uninterrupted with the events too. So in that middle part, she kept changing this one area. She would stop talking and narrate her story. But other than that, it's very clear to me.
And is it pot? She also mentioned that she was thinking about assaults that she had sustained in the past.
As a reaction of when Harvey was approaching her, yes.
And as for your pursuit at 55 miles an hour, at what point did you turn on the lights and sirens?
As soon as I was able to catch up and being a few good areas, I was worried that I was going to initiate my lights and sirens, or my lights, I mean my sirens. I was going to be too far from him to even make him think that I was attempting to pull him over.
So during the high-speed component of the chase, there was lights and sirens were not on?
As I was pacing.
Right. And when you talked to Mr. Harvey, he denied that there was a physical component to this argument.
Correct.
Did he tell you anything about any injuries he sustained?
No, he just told me it was verbal, so I didn't imagine that it got physical at all.
Okay, thank you. Nothing further.
Thank you, Direct.
No,
Next officer be excused.
yes.
Thank you, Officer Moore. Part of that witness.
Kind of the people have no further witnesses at this point.
Thank you. Are you calling any witnesses today, Mr. Adams?
No, thank you.
Okay, to argument.
Your Honor, Mr. Harvey is only charged with one felony, which is the assault with intent to do great bodily harm, less than murder, by strangulation and resuscitation. I think there's been a sufficient basis for the testimony, obviously, to come in, and it's clear to me, at least, based on the pictures, the way that the injuries were described to the officer and the way that he described them to us, that the injuries that she sustained are consistent with the statements that she made to the officer. He did indicate that they appeared to be fresh, some new injuries, and there was a clear point in time in which the defendant did place both hands around the victim's neck, had her pinned against the wall where she had a hard time breathing, and was in fact gasping for air, and this took place over approximately 3-minute time period. Before the defendant fled the area and was able to be stopped by the officer leaving the location, wherein the defendant in fact put himself at the location prior to leaving the area. I would ask that it be bound over, obviously count 2, the domestic violence, even the second offense notice, and the count 3, malicious destruction of personal property and misdemeanors that follow along. I'd ask that it be bound over as charged at this time.
Thank you, Mr. Abbott.
Thank you, Your Honor. As the officer testified, the witness was confused with parts of her story. And she was also recalling prior assault or events in her past. It's important to bear that in mind when evaluating whether there's probable cause.
Thank you. Today was the date set for preliminary examination. For your benefit, Mr. Harvey, the burden is on the prosecution at this stage to present sufficient evidence to show the court that there is adequate probable cause that a crime was committed and adequate probable cause to charge you with the crime. Probable cause is a standard that's measured as more than just mere suspicion that a crime was committed. But again, it is not nearly as much information or evidence that will be necessary at the time of trial, because the burden there is beyond a reasonable doubt. So the standard here is much lower. And today testimony was presented by Officer Moore under MCL 768.27C. And the testimony provided that there was an incident or a call that Officer Moore reported to the area of 4540 West Willow, apartment B12 in the city of Lansing, Ingham County, state of Michigan on May 15, 2022. This testimony was elicited indicating that when the officer reported, he made contact with a lady or a victim by the name of Letitia Lewis, who indicated that her ex-boyfriend arrived in a red Charger and that he had assaulted her. She described an incident or an altercation that took place. I believe the testimony provided that the incident was provoked by the defendant or the person identified as being the defendant being upset about Miss Lewis dating another individual. The officer testified that when he arrived, he noticed that that the victim had a bruise. Also, that while she was recanting the alleged incident, she had mentioned that she had been knocked out twice, and that he believed her to be experiencing some confusion, which based on his training experience would be an indication to corroborate the possibility of her having been knocked out or unconscious during or immediately during this interaction. Mr. Abbott is arguing that he would like the court to consider that and making the determination as to whether or not the statements provided by the declarant are reliable or trustworthy. I find that the information that was provided in the circumstances, including the bruising that was noted by the officer, including the damage to some property as evidence in plaintiff's exhibit or people's exhibit 1, and the pictures of bruising, it looks like around the alleged victim's neck and her cheekbone in people's exhibits 2 through 5. would seek to corroborate or do serve to corroborate that there was some kind of interaction that had, or assaultive action interaction that took place, causing these bruises to come about, and that if true, that if the defendant had knocked or caused the victim to be unconscious twice during this incident, that she would likely have been suffering some confusion while coming or becoming alert during that time. So the court is satisfied that there's sufficient probable cause as to count one, which was assault with intent to do great bodily harm less than murder or by strangulation. I find that the statements were reliable and trustworthy, and that the assault included Mr. Harvey at some point placing his hands around the victim's neck for approximately 3 minutes. I believe what the testimony was, and squeezing. So that will be bound over to the circuit court. Count two is a misdemeanor, it will accompany. He said there was a, okay, count three of malicious destruction of personal property, $200 or more, but less than $1,000. The photographs of the alleged items to be damaged include a sofa and some jeans. Not sure how much the jeans would cost with the sofa. I'm sure it was more than $200. So the court is satisfied that there's sufficient probable cause as to count three. Well, not that it's necessary, but it'll be bound over as well with the felony that's being bound over. Your bind over date, sir, is going to be June 15th. You do not need to appear in court on June 15th. That's the date they get the file from this court. You're not going to have a arraignment in the circuit court unless Mr. Abbott provides the circuit court with a motion requesting arraignment. Okay? The next court date in circuit court will be a pretrial. Mr. Abbott will be made aware of that date. He'll be in communication with you, okay? And bond was set at 5,000 personal cognizance. That will continue. Any additional matters for the record?
None further people.
None from the defense. Thank you, Your Honor.
Thank you. You're all set, sir. Okay, we ready for our next one?
Our compliance officer court, so active. Sure.
Mr. Hooper,
Yes, it is, Your Honor.
we're on the record in the matter of the people of the state of Michigan versus Isaiah Hooper, file number 22-01318 FY council appearance.
Morning, Your Honor, Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Attorney John Abbott representing Mr. Hooper. He is present and seated to my right.
And today's the date that is set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
No, Your Honor.
No,
Actually, Your Honor, I'm not sure, but there may be another witness in the court. I might ask for a sequestration.
Okay, sequestration order is granted. Do we have any potential witnesses in the courtroom?
Yes.
Okay, okay, I don't know who that potential witness is. Okay, ma'am, there's a sequestration order, so you're gonna have to step outside, okay? Okay. Any other preliminary matters?
No, Your Honor.
Okay, you can call your first witness.
Thank you, Your Honor. For the first witness, we will call this man Officer Rob Corbett.
Do you solemnly swear or affirm the testimony you're going to provide is true to the best of your knowledge, information, or belief?
Yes, Your Honor.
Thank you, sir. You can have a seat. Please state your first and last name and spell them both.
My name is Robert Forbes, ROBERT, FORBIS.
Proceed, counsel.
Thank you. Officer Forbes, can you please state your occupation for the record?
Yes, I'm a police officer with the city of Lansing,
And how long have you been employed by the city of Lansing?
23 years.
Okay, I want to take you back to May 17th of 2022. Were you working in your capacity as a police officer on that date?
Yes,
Were you working alone or with a partner?
alone.
And what kind of vehicle were you in? Was it fully marked?
Yes, I'm currently assigned to uniform patrol and wearing my police uniform and driving a fully marked police vehicle, fleet number 39.
Thank you. And on that date, did you have the occasion to be present at Willow and Knollwood in the city of Lansing and county of Ingham, state of Michigan?
Yes,
And how did you get to that location? Or what prompted you to go to that location?
that location, I've worked this particular neighborhood for several years throughout my career. And I know that location to be an area of high crime with violent crime and narcotic activity.
Okay.
And so I was in the area just conducting hotspot police.
Okay. And while you were doing that hotspot policing, did anything catch your eye?
Yes, it did.
And what was that?
I saw two subjects. One was a male, the other was a female, and they were walking westbound on the sidewalk of Willow. And the way that they were walking directly at me from
That's fair.
I would say less than a block away.
Okay.
And the reason that they stuck out was because I saw that the male subject had a bag over his shoulder, and the bag was swinging unusually, and he was making retention touches to the bag, which, based on my training and experience, led me to suspect that he was armed.
And this bag, what kind of bag was it, if you could describe it?
Yes, it was a one strap bag that I guess, for lack of a better term, like a fanny pack, some people call it.
Mhm.
But rather than wearing it around his waist, he was wearing it around his shoulder, around his chest,
And was the bag itself on his front or his back?
on his front,
Okay.
clipped over one of his shoulders and under his other arm.
Okay.
What kind of material was this bag?
I'm sorry, I didn't.
material was it made of? Do you know?
Yes, I remember it being a black leather or maybe a faux leather.
And you said he was making retention touches of that bag,
Yes,
and based on your training and experience, those retention touches are consistent with what? I'm sorry.
it is consistent with my training that I obtained during my tour with the Violent Crime Impact Team. I attended the training that was hosted by the ATF that was specifically for recognizing subjects who are armed. And this was definitely consistent with the training from that school.
Okay, and you said they are approximately a block away from you, is that correct?
Yes,
And the person that you observed to be wearing that bag, is that person present in the courtroom today?
yes,
And can you recognize that person wearing a mask?
yes, again,
Okay, and can you please point to that person and describe what they're wearing for the court?
yes, seated to my left, wearing a gray shirt.
Thank you. Now, please let the record reflect that the witness has identified the defendant.
Any objection to identification?
Motion.
Okay, identification is noted.
And what did you do after you observed swinging in the retention charges?
At that point, I pinpointed my focus on the subject. And I used my binoculars to essentially zero in on his behavior and his movement.
Okay.
And I saw that the female that he was walking with, they arrived at the corner store, the liquor store, and the female went inside the store by herself.
Okay.
And when she did that, the male subject, Mr. Hooper, remained outside in the front area outside the store where I was directly observing.
Okay.
And I saw that he took a purple mask from his pocket and he placed it. It was not a mask like he's wearing right now that just covers his nose and mouth. It was a mask that went over his hairline and his whole face, so that the only thing showing was essentially his eyes.
Okay. Did that stick out to you?
It did, because I didn't. It was just unusual for the simple fact that there was no one around. I mean, it wouldn't be unusual in this day and age for someone to have a mask on, of course, but it was unusual that he's standing in the middle of an open area by himself with nobody near, and then he put a mask on it that covered his entire face. It was just odd to me at the time.
Okay.
And he still had the shoulder bag or the bag over his shoulder. And I saw that he unzipped the bag and put his right hand inside the bag. It was clutching an item inside the bag.
Okay.
And that definitely piqued my suspicion that he was armed. And that was all verified while I was watching him directly.
Okay.
Because he took the gun out of the bag slightly to the point that I could completely 100% identify that he had a gun inside the bag.
Okay. And what part of the gun were you able to see?
I was able to see the part of the handle and the top of essentially the back of the gun. So like the rear sights and slide.
Okay. And then what did you do after you saw that?
I was not at the time. I was very alarmed at his behavior standing outside, for the simple fact that he was outside the store while the female was inside for several minutes. While she was inside the store and he had his hand on the firearm with a full mask on that he just put on, and he was looking around the neighborhood, scanning very unusually, that to the point that I didn't know what his intentions were, but it certainly led me to believe that he was going to do a robbery of the store.
Okay.
But let's be clear, that none of that ever happened, but that was my observations and my suspicions.
That's fair.
And going to.
Yes.
The female came out of the store. He was waiting for her, and when she came out of the store, they walked together back eastbound on the same sidewalk, essentially with their backs to me at that point.
Okay. What did you do then?
I radioed for backup and communicated that I communicated my observations, and I made it clear that I did not know all the details of why he was looking around and so forth, but it was clear to me at the end of the day, he was no question in my mind that he was under 21.
Okay.
That made him ineligible to obtain a CPL permit. Thereby, at the very, very least, he's carrying a concealed weapon illegally because he would be too young to obtain a CPL.
Fair. And did you eventually make contact with Mr. Hooper?
Yes,
Okay. And what happened when you made contact with him?
I my backup unit was very, very close. And as they were walking, as the male and the female were walking away, I communicated with the backup unit and pointed out Mr. Hooper to the backup unit and said a summary of what I just described in court. There's absolutely no question he's not 21. There's no question that he's armed, and so we're gonna make contact based on it. And I drove my patrol car directly next to him. So where he was on the sidewalk and I was in the street. So within, I would say 10 feet. I told Mr. Hooper, stop police from my patrol car. And with my driver's window down, I pulled right up to him and said, stop police. He looked me right in the face and took off.
Okay. And what happened next?
What happened next was, because I was still in my car, I was able to drive faster than he could run. So I drove east a couple hundred feet maybe, and was able to drive ahead of him in the apartment complex entrance, while the backup unit was essentially behind him, and he realized that essentially he was surrounded at that point, and he was completely compliant and got him.
Okay. And after you made contact with him, were you able to recover the firearm?
Yes, when he was arrested on the ground, he was still wearing the bag, and so I handcuffed him. And at that point, after he was handcuffed, I unclipped the bag, and the firearm was inside.
Your Honor, I'm going to show us and mark as People's Proposed Exhibits 1 through 4. Okay. Permission to approach, Your Honor?
Yes.
Officer Purvis, you just look at those photographs and tell me if you remember them. And how do you remember them?
These are the photos that I took of the recovered firearm, the black bag, and Mr. Hooper's ID card that he had on it.
Okay. And those are all accurate depictions of what they look like at the time you took those photographs?
Yes.
Okay, Your Honor, after those minutes, we will exhibit 1 through 4.
Any objection?
No, thank you.
We will exhibit 1 before I admitted. I just have a quick question. You said this was May 17th, 2022.
Yes.
Do you remember what time of day it was?
Yes, it was It was the middle of the day. I would say approximately 6 o'clock, 5:36.
Oh, okay, so it's pretty light out. But,
Broad daylight.
thank you.
And you indicated that he was under 21, is that correct?
Yes,
And you cannot obtain a CCL license until you're 21, is that also correct?
exactly.
Uh, Did you, in fact, have a conversation with Mr. Hooper?
I did.
And did he make any admissions to you with regards to the weapon?
Yes, he did.
Just that he had it on his person?
Yes, he said that he had it on him because of I'm summarizing, but essentially, he lives in an area of constant fear for his safety and felt the need to arm himself, and that the method of which he obtained this firearm likely it was clear in his mind that it was likely either used in a violent crime or that it was stolen because of the means here.
I have no further questions, Your Honor.
It could just be my eyes playing tricks on me. Is this black or blue? I don't know.
It's black.
Okay, because in some of the pictures it looks blue, and I'm like, what color is this? I think it's the way the light is hitting.
Yeah, it's
Okay.
actually, there's a window and the sun is right through the window, kind of causing a little glare.
Got it. Okay, sounds good. Prosecution.
Thank you. Work backwards. So the gun was obtained under circumstances that suggested it was a hot gun.
Yes,
And the reason was because it was so expensive.
he didn't want to elaborate on who he purchased the gun from, but I remember him saying that he bought the gun the day prior to this incident, and the price of the gun was very, very low, leading it illegitimate purchase on the street.
Right, hotter than a $3 gun.
Probably.
But there was no indication that he was involved in whatever that crime stuff was.
No, clearly not.
And you said you could tell for certain he was under 21. How old do you think he was?
I was thinking at the time, 16 or 17.
And you said it was daytime. How is it possible that he couldn't see you? Where were you parked?
I don't know how he didn't see me. I was parked. I don't know the exact distance, but I would say 50 or 60 yards directly west of the liquor store.
Okay, parked like at the curb?
Yeah, so there's it's a little challenging to describe, but there's directly across the street from the liquor store is a very small plaza of some other businesses. I think there's maybe a barber shop or like 2 or 3 businesses in a little plaza, and that is on a very short entrance, and there's some parking, and I was near that.
Okay. And did you say you had binoculars with you?
I did.
How strong are those binoculars?
I'm not sure of the technical data on that, but they're very small.
And so you were about 60 yards away
Yes,
with binoculars,
yes.
and you could see clearly that he had a gun in his hand when he pulled it out of the bag.
The
And you mentioned that as he was walking towards the store, the swinging of the bag was consistent with the gun. Right.
Yes,
would also be consistent with like 4 rolls of quarters, right?
Objection, culture speculation.
No, I'm not asking for speculation. All right, so talking about a heavy object swinging along in a bag. It could have been
Yes.
4 rolls of quarters.
Yes,
I'll allow the answer.
Thank you.
Yeah.
But it wasn't until he actually pulled it out that you knew for sure it was a gun.
that verified all of my suspicions of the characteristics that I saw of that.
Did you have your dash camera activated during that?
No,
And when they left the store, did he still have his purple mask on?
yes,
So when you caught him, he still had the mask on?
yes,
2 other questions, maybe not particularly relevant. You confiscated the telephone,
yes.
and that's no longer necessary for this investigation?
I don't, the answer to that is I don't know. The reason that I don't know is because the fact that the firearm came back stolen and lean, and the circumstances around that investigation, I don't know if our detectives are going to want his phone as evidence related to that.
Thank you for clearing that up. And this is an open carry state, right?
Yes,
So if he had had the firearm in a holster on his waist, it would have been okay? Been legal?
sorry, I know, yes.
Thank you, nothing further.
I have a question before I let you do any redirect. I know you mentioned the purple mask. When they left the store, do they still have the mask on his face?
Yes, ma'am.
Okay. You can proceed.
Sure, I do have a picture of him after he was detained, if you wanted me to enter it as evidence with the mask on. I don't think it's necessary, but I have no further questions for Officer Forbes.
Thank you, Officer Corbett. You can be excused.
Thank you.
Any additional witnesses?
No, Your Honor.
And to be calling witnesses?
No, thank you.
You can proceed to argument.
Your Honor, I think it's clear from Officer Forbes' testimony that Mr. Hoover was carrying a firearm that he was not able to possess inside of that bag, as Mr. Abbott pointed out, that it may have been legal for him to carry it if it had been observable on his person, but it was not. It was clearly concealed within that bag, making it illegal to carry at the time. Especially considering at the time of the offense, I believe Mr. Hoover would have been around 18 or 19, making him ineligible to even possess a CPL. So no way for him to legally possess a firearm that was not able to be seen. I'm asking to be bound over as such, or as charged. Thank you.
Thank you, Your Honor. Leave it to the court's discretion.
Okay, Mr. Hooper, today was the date that was set for your preliminary examination. The burden at this time is on the prosecution. They needed to provide sufficient evidence that there was probable cause that a crime was committed and probable cause sufficient to charge you with the crime. That burden is just more than mere suspicion. It's not to be compared with the burden that you will face if this matter is to proceed to a trial. That will be beyond a reasonable doubt. That requires a lot more evidence. But again, today, the court's just looking for more than mere suspicion. And we have testimony today from Officer Rob Forbes. He was in the area of Willow and Norwood in the city of Lansing, Union County, state of Michigan, on May 17, 2022. At some times it was midday, but around 6. But in May, that it would be still daylight, of course, in this area, when he observed 2 subjects walking westbound on Willow. He said that what caught his attention was that they were walking directly, what appeared to be directly towards him. He said that he noticed that the individual he identified as the defendant, Isaiah Hooper, had a bag, which he described to be a fanny pack leather or faux leather style, placed in the front of his person, but that it was over his shoulder some way, and that it was swinging um, in a manner that would allow him to believe that there was possibly a firearm or maybe 4 rolls of quarters in the bag or something weighted. The officer testified that he used binoculars to zero in on the defendant to observe his behavior. He saw the female that was with the defendant enter into the store. The defendant stayed or remained outside of the store. He said he noticed the defendant remove a purple mask from his pocket. This is a mask. He said that it covered the entire face. He placed this mask on. The officer thought that to be strange because there was no one around. And so even in the midst of still being in a pandemic, found it to be peculiar that he would pull out a mask while standing alone outside the store. He said he saw the defendant unzip his bag, put his right hand in the bag, and appeared to be clutching something. He said he then noticed or observed the defendant take a gun slightly out of the bag, but out further enough for the officer to be able to identify that it was a firearm. He could identify, or he was able to see the handle or the back of the gun. And so the officer believed, based on the circumstances, that maybe the defendant was planning or going to rob the store. He did clarify or indicate that none of those actions ever took place. But he also believed, based on his observation of the defendant, that the defendant was underage. He testified that he thought the defendant might have been about 16 years old. He attempted to stop the defendant by ordering him to stop, indicating he was the police. He did indicate that he was in a fully marked vehicle, patrol vehicle, and fully marked uniform at the time that the defendant took off running. Officer was able to catch up because he was driving, and the defendant became compliant. Firearm was later determined to be stolen. We do have photographs of the firearm here in People's Exhibits 1, 2, and 3, along with an Exhibit 4, which is a photograph of Mr. Hooper's identification, showing that he is under the age of 21 at this time, or much older than 16, which the officer believed. Nonetheless, the court is satisfied that there's sufficient probable cause based on the totality of the circumstances presented today for the officer to believe the defendant was carrying a concealed weapon in violation of the law. That matter will be bound over to the circuit court for a bind over date of June 15th. You do not need to appear in court on June 15th, Mr. Hooper. That's just the date. The circuit court will get the file from this court. Your next court date in circuit court will be a pretrial. Mr. Abbott will be made aware of that court date. Okay, sir? I didn't hear you. Did you say something? Okay, I said okay. Did you understand what I just said? Yes, ma'am. Okay, thank you. Bond in this matter was set at $2,000 personal recognizance. That will continue. Do you have any additional matters for the rest of it?
Nothing from the people.
Nothing from the defense, thank you.
Thank you. You're all set.
Abbott, John, Teddy, ready for you.
Yeah.
Absolutely. And Your Honor, the people are prepared to proceed on Jason Phillips. All witnesses are ready.
The court is ready to proceed as well. Okay. Susie probably didn't realize that. I think she assumed she had more content for always.
There are a lot happening in a very short amount of time, so
Yeah.
that makes sense.
Okay. Are we ready?
People are prepared.
Yes, Your Honor.
Okay, we're on the record in the matter to the people of the state of Michigan versus Jason Michael Phillips. File number 22-01286 and 22-01316. FYI, council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. May it please the court, Assistant Public Defender Steve Cornish on behalf of Mr. Phillips, who's in the court and standing to my right.
Thank you. Today's the date that's set for preliminary examinations on both files. Are we ready to proceed on that?
Yes, Your Honor, and I would ask that we hold examination for both files simultaneously, given the frankly overlap in time and people.
Mr. Cornish.
I guess I don't really have an objection to that, Your Honor. For prelim purposes, I think that's fine.
Okay, we will hold them simultaneously. Any other preliminary matters?
Not from the people, Your Honor.
Nothing from the defense, Your Honor.
Thank you. You call your first witness.
Thank you. The people would call Miss Tonya Wakefield.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat, please. Let's make sure your phone is off. Okay, there's a microphone in front of you. When you said yes under the oath, I could barely hear you. So can you give me a check, a sound check, please? Can you say your name?
Tonya Wakefield.
Okay, very good. So Ms. Wakefield, I have a court reporter. She's behind you, but she has to take down everything being stated in the courtroom today. So we need your responses to be loud and clear, but we also need them to be verbal. So you can't do head nods or head shakes. You also can't do uhs and ahas because she can't write that into the record, okay?
Okay.
If there's an objection by either of the attorneys, you would stop your response. I'll make a ruling on the objection. I'll let you know if you can give your answer or not, okay?
Okay.
You state, or you said your first and last name. You spell them both for me.
TONJAWAKEFIELD.
Thank you. You can proceed, counsel.
Morning, Miss Wakefield.
Right.
Now, right off the bat, do you reside at 1124 Bench Street? Is
Yes.
that in Lansing?
Yes.
Is that in Ingham County?
Yes.
Did you reside there as of 5/13 of this year?
Yes.
And who else lives there with you?
My husband and my two children,
And what is your husband's name?
Laverne Wakefield Jr.,
And your children's name?
Laverne Wakefield III, and Trinity Wakefield.
So a man by the name of Jason Phillips doesn't live there, right?
No, sir.
You happen to know someone by that name?
Yes.
And how do you know that person?
It's my friend Rachel's husband.
Is that Rachel Phillips?
Yes.
And on that day, did he have any permission to be at 1124 Bench Street?
No.
And would you be able to identify him if you saw him again, even if he was wearing a mask?
Yes.
And do you see him in the courtroom today?
Yes.
Could you please indicate where he's located and something he's wearing that differentiates him from the other people? If he,
I couldn't hear her.
I couldn't hear either.
The blue jumpsuit on the left over here.
Thank you. The record reflect that she is pointed at the defendant. I'd ask that the record reflect she has identified him in this matter.
Any objection to identification?
Not for prelim, Your Honor.
Identification is noted. And ma'am, you can remove your mask if you want during your testimony, okay?
We know it's difficult to talk behind a mask. Now, on 5/13 of this year, do you know if your daughter Trinity was at the residence?
Yes, she was.
And had you been at that residence earlier that morning?
Was I?
Yeah.
Yes.
And was there any damage to your front door of that residence before you left the house?
No.
And was there any when you got back?
Yes.
If I have permission to approach the witness with what's been marked as people's proposed exhibits 3, 4, 5, and 6.
Okay.
Ms. Wakefield, I'd like you to look at those exhibits in front of you. Those photographs, do you recognize them?
Yeah, that's my photo. And that's the pieces of the bedboard that got busted out.
Let the record reflect that she was identifying people's proposed exhibit 3 during that last statement. But so these are photos of your door and the damage that you had found once you had come home later that day?
Yes.
And does that appear to be an accurate reflection of the door and the damage?
Yeah.
Your Honor, I would seek to admit people's proposed exhibits 3 through 6.
Any objection?
No, Your Honor.
People's 3 through 6 are admitted.
Thank you. And I would seek to publish it in the court at this time.
Okay.
Now, were you eventually told what happened to your door?
Yes.
And was that Trinity who told you?
Trinity and my son called from the closet inside and
It sounds like it's about to be hearsay, Your Honor.
Your Honor, this I'm not going to be asking for this to be admitted as truth of matter asserted. That will be in Trinity testifies. This is only to go to the witness's state of mind.
Okay, the objection is overruled because it's not been enough for the truth of the matter asserted.
Thank you. And so she say who had damaged the door?
Yes.
And who was that?
Jason.
And then did you receive text messages from him later that day?
Yes.
Do you happen to remember about what length of time passed between what Trinity said happened and you receiving the text messages?
I'd like to say it was probably within the hour.
So fairly quickly.
Yeah.
Do you remember if it said anything involving violence towards you?
One of them, yes.
That's something along the lines of I'm blowing your fucking brains out.
Yes.
Did he also offer to fix your door or buy a new one?
Yes.
And you show those text messages to police officers?
Yes.
I'd like to approach with what's marked as people's proposed exhibits 1 and 2. Ms. Wakefield, do you recognize the text messages that are in those photographs?
Yes, I do.
And are those the text messages to and from Mr. Phillips during that time period you're just speaking of?
Yes.
And do those appear to be an accurate reflection of those text messages?
Yeah.
I just want to include that line of I'm going to blow your fucking brains out.
Yes.
Thank you. At this time, people would move to admit people's proposed exhibits 1 and 2.
Any objections to people's 1 and 2?
Very brief one, Your Honor.
Absolutely.
Thank you. Could you show me on those exhibits where it says Mr. Phillips?
Not on those, but I do still have them in my cell phone.
Who does it
And it
indicate?
shows the phone number.
Who does it indicate those are from?
It says not.
Is that another person or is that a nickname you have for Mr. Phillips?
It's a nickname.
For Mr. Phillips?
Yes.
You didn't see Mr. Phillips send these, is that correct?
I'm sorry.
You did not see these come, Mr. Phillips send you text. He wasn't standing near you or you could see him texting you.
No, but they did come from his number.
They come from the number you associate.
Yes.
Thank you, Your Honor.
Any objections to people's one and two?
Not at this time, Your Honor.
One and two are admitted.
People would seek to publish them to the board at this time.
Okay. Thank you.
Now, were your children and your husband the only individuals at your residence that day, or was there somebody else?
Rachel and her children were there earlier.
Does that include her daughter?
Adriana, yes.
Adriana, thank you. And you know if that's a child that she has in common with Mr. Phillips?
Yes, it is.
Thank you. At this time, people have no further questions for this witness.
Okay, I just need to clarify these exhibits because people's one have a time frame indicated here of 9:15 p.m. and then people's two have a 4:87 and I'm saying 8:47 and 8:37 p.m. So is people's exhibit two the first order of sequence and how the text messages came in and then these ones, or is it the reverse? Do we
Can I see
know?
them?
Yes,
So it may very well be that I
I think that was how the officer marked it, because that was what it said, so I think that. But was, or was it a different day? I don't know,
I can ask a brief question, Your Honor.
please.
These text messages you saw, they came in at the same day,
Yes,
this day,
yes,
just not directly next to each other.
correct.
Thank you.
Okay,
I do believe that people's proposed exhibit 2 comes before
thank you.
exhibit 1.
Okay, cross exam.
Your Honor. It's Miss Wakefield?
Yes,
Miss Wakefield, you and Rachel Phillips are friends, is that correct?
yes,
How long have you guys been friends?
since 2012,
It's quite a long time.
yes,
And it's your understanding, without getting any specific details, that there was problems at home with her, is that correct?
yes,
So you let her come to your house and stay there?
yes.
You'd do pretty much anything for Miss Rachel, wouldn't you?
If it's helpful, yes.
You don't know for certain who sent those texts, do you?
Yes, I do.
You know whose phone number it was from, but you don't know who sent them, do you?
Well, he called and said the same thing over his telephone.
At the same exact time as those texts were sent?
Few hours later.
And when you say the same exact thing, you mean he offered to fix your door?
Yes.
Did he also threaten you over the phone call while talking to you?
Not on the phone call.
So when you say that you know who sent them because he called, you're saying you know who sent the text messages offering to repair the damage to your door, but you don't know who sent the texts that were maybe an hour or so later threatening you. Is that correct?
I know it came from his phone number.
You understand the distinction I'm making though? Knowing it came from a phone number versus knowing who actually sent the text. Is that a yes?
Correct.
Thank you. And you would agree you don't know who sent the text at 9:15 p.m. that day?
Objection, Your Honor. Ask and answer at this point.
I don't know that she's ever actually answered my question. She said she knew the distinction. And then when I asked her if she knew the distinction, she corrected herself and said, yes, I understand the distinction. So now I'm making sure she's actually answering my question.
Okay, so the text message actually was at 9:17, so I think the blue is her. That was at 9:15. The white, I believe, is what she's saying was the defendant. So you're asking about the text message at 9:17?
The ones that the people's two. Or is it-
Correct, but that she said, I think hers was at 9:15.
Oh, there's like the ones that are going back and forth. Yes, you're correct. I'm sorry.
Okay,
Just make
and
sure.
so
we
you're
correct it.
asking her if she knows for sure.
Who sent the 9:16 and the 9:17 PM text, which would be the fuck you, I'm coming there next, where's my kids? And then the 9:17, I'm blowing your fucking brains out, where is my kids?
Okay, yeah, she can respond to that.
I wasn't there when he sent the text. No.
When whomever sent the text. Thank you.
Well, the question wasn't were you there, ma'am, it's do you know who sent the text?
Well, I guess he wouldn't have sent the text if I was right next to him to watch him send it.
Right, but these aren't the questions, man.
You have no personal knowledge.
Where, I'm not asking you
No.
if you see him send the text or not. That's maybe what your question was. That's not my question. Do you know or have reason to know who sent this text to you?
It is my belief that it was him,
Okay, and why do you have that belief, ma'am?
because those are the same texts that he had been sending.
Any other questions on that?
Not on that area. I'll
Thank
move
you.
on. You were not home during this
I'm
alleged
sorry. the
home invasion,
recordings-
is that correct?
Sorry, the recordings having a glitch. You can keep going. Okay. you can go. Yeah.
You were not home during the alleged home invasion, is that correct?
Correct.
So everything you know about the event itself came from your children?
Yes.
Let's back up.
Just making sure you- I have nothing further this time around. Thanks.
Thank you. Any redirect?
None, Your Honor.
Thank you, Ms. Wakefield. You can be excused. And you can call your next witness.
People call Trinity Wakefield.
Raise your right hand. Face me. Nope, stand and face me. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? I need to hear you, ma'am.
Yes.
Thank you. You can have a seat right there. Okay, you're free to move your mask if you feel comfortable during your testimony. But more importantly, there's a microphone that's in front of you, a court reporter behind you, and she has to be able to hear all of your responses, okay? Can you say your name so we can test your volume? Okay, I need it to be a little louder because the attorneys have to hear you too, okay? Can you say your name again? Okay, can you remove your mask for me? Are you able to speak as though you're yelling? Okay, if there was an emergency and you needed to let your mom hear what you were saying, would you talk louder than that? I need you to give me that voice, okay? It's okay, but we need to make sure we can document everything that's being said. And I recognize you may be a little afraid. Is that what's going on? Okay, you do not need to be afraid, okay, ma'am? Okay, you're in the courtroom. We're safe. We have a court officer in here and we have some law enforcement in the hallway, okay? Okay, so your responses must be verbal. They must be loud. We must be able to hear a yes or a no if it's a yes or no question, because we can't write down head nods or shakes or uhs and ahs, okay? Can you spell both your names for me, your first and last name? Okay. So again, I'm gonna remind you to try to speak as loudly as possible, and it's okay if you feel like you're yelling. We'll allow it, okay, so that we can make sure we hear you. You can proceed, counsel.
Thank you. Good morning, Trinity. Now, I want you to basically try and talk like you're talking to your mom in the back row, okay? At that kind of volume. I know it's difficult, it's even difficult for me as part of my job. Just want you to do your best for it, okay? So big, okay? All right. Act like you're talking to your mom at the volume that she'd need to hear you at, okay? Now, Trinity, were you at your house on 1124 Bench Street on 5/13 of this year? And was that the day that you interacted with police officers? And who was at the home with you? You try speaking up just a little bit.
The little girl, her brother, my brother, and then
Little girl, do you mean Miss Phillips' daughter? Now, when you were at the home, did you hear some banging on the door?
yeah,
And what did you do?
I woke up and I noticed that it was Jason.
So you said you realized it was someone named Jason. Do you know someone named Jason Phillips? And how do you know?
I can't hear anything she's saying.
He tried. Thank you. Now, so you saw him outside your door.
I saw him walking up the door.
Okay. Now, would you be able to recognize him again if you saw him, if he was wearing a mask?
Yeah.
Do you see the man who was at your door that day?
Yeah.
Could you please point out where he's located? Maybe something he's wearing to separate him from the other people in the room? A suit or a jumpsuit? Jumpsuit. We got two people with blue suits. Want to make sure. So it's the man furthest to the left was where you pointed?
Yeah.
If the record reflects, she's identified the defendant in this matter.
Any objection to ID?
No, Judge.
Identification is noted.
Thank you. So when you saw it was Jason, what did you do?
I told that person that morning and that and I was
Why'd you take her there?
the
You were worried about her safety
Yeah.
because of Mr. Phillips? And so, did at any point he get inside the house?
Yes,
How did he get inside?
he was punching the arm of the
And did the door eventually get damaged?
Yeah.
And so he made his way in through the front door after it got damaged?
Yes.
You didn't open the door for him or anything like that, right?
Is that a no?
Yeah.
To clarify, yes, it was a no, right? Okay, just want to make sure. And to your knowledge, he wasn't allowed to be in your house, right? He wasn't living there or anything like that?
No.
So what did he do once he got inside your house?
I was in the kitchen, so he went for
You got pushed to the wall?
Yeah.
Who pushed you? Jason. And so he put his hands on you. What part of your body did he touch to push you? Your arm. You indicated it was your right arm. That's, if you don't remember, that's okay. I just want the record to reflect that you had motioned on your right arm, but if you don't remember which one, that's perfectly okay. And I'm assuming you didn't want him touching your arm. And did he say anything while this was all happening?
He was screaming, "Where are my kids?" And he took my kids, where are they?
He was screaming, "Where are my kids? You took my kids. Where are my kids?" And you know if the little girl is his kid?
Yeah.
Did he find her?
He went to the basement and stared at her, but he just went right back up once the police went.
So you called police?
Yeah.
And it was at that point that he left. That's okay. No, he's saying anything that that you're unsure about, just what you remember. Do you remember how this made you feel when the door was broken in? Scared? So did you talk to your mom afterwards? Tell her what happened? Did you also tell the police officers about what happened that day? And to your knowledge, your door was working just fine before he came banging on the door, right?
Yeah.
Thank you. Your Honor, at this time, the people have no further questions for Ms. Wakefield.
Thank you, cross-examine.
Briefly, Your Honor, appreciate it. Oh, no, have a seat. My turn. Hey, good morning. I just have a couple of questions for you, okay? I gotta tell you, I'm having a real hard time hearing you. It's okay if you want, you can take it down below your mouth so we can hear you better. If you don't want to, that's fine too. I just gotta have you speak a little bit louder, okay? All right, thank you. So going back to the day in question we're talking about, right? Thank you. You said you knew that Jason's daughter was in your house? And Jason B is Mr. Phillips in the court, right? And Rachel wasn't there. So it was, it's her name, I'm gonna butcher this, I'm gonna say Avriana. Okay, and that's Avriana for the record. So it was just you, Avriana, you said another little boy? Avriana's older brother. Okay. And was anybody else there?
My brother and
Your brother and father?
Yeah.
Okay. How old's your brother?
13.
Was your dad awake or asleep? How long was Mr. Phillips knocking on the door?
Not really nothing, but it really got up. He just like started taking it.
And he was yelling, "Where's my kids?"
He wasn't young, so he got me so good.
Did he ask you where his kids were when he was knocking on the door?
No.
Nothing further, Your Honor. Thank you.
Thank you. Any redirect?
Very briefly. Trinity, you've had people knock on your front door before, right?
Yeah.
Is that what this sounded like?
Yeah.
How did this sound different than when people normally knock on your door? Sounded angry? Okay, so it didn't sound like it was just trying to get someone's attention. Sound like it was actually trying to get through. Thank you. There are the people have no further questions for this young lady.
Okay, thank you, Ms. Wakefield. You're free to go. You can call your next witness.
Yes, Your Honor. The people who called Rachel Phillips.
Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yeah.
Thank you. You can have a seat there. There's a microphone in front of you. And a court recorder is sitting behind you. She's gonna have to take down everything being stated in the court today. So if you can keep your responses loud and clear, you are okay to remove your mask if you're comfortable during your testimony. If there is an objection, you would stop any of your responses so that I can make a ruling on that objection, and then I'll let you know if you can give that answer or not, okay? The other thing is the yes or no's that always gets people, try not to use mm-hs or uh-huhs or head nods, because then we'll have to ask you if that's a yes or a no, okay? Can you state your first and last name, spell them both? Okay, you can proceed, counsel.
Thank you. Morning, Ms. Phillips. Now, I want you to do your best to speak up so everything can be heard. If you need to remove your mask to do so, you are free to do that, okay? Now, I'm going to try and take you through this as plainly as I can. Just tell us what you remember happening, okay? Things like I don't know or I don't remember are perfectly valid answers. Now, you're Rachel Phillips. Do you know a Jason Phillips?
I do.
And how do you know him?
We're married,
How long have you been married?
8 years,
Do you have any children together?
1,
And what is their name?
Adrian Phillips.
How old is she?
She just turned 7.
And do you reside at 1227 Mechanic?
Yes, I do.
Is that in Lansing?
Yes.
Sanningham County?
Yes.
Now, does Mr. Phillips normally reside there?
Yeah.
Would you be able to recognize him again, even if he was wearing a mask?
Yeah.
Do you see him in the courtroom today? Could you please identify where he's situated, something he's wearing to differentiate him from the other people in the courtroom? Thank you. Your Honor, if the record reflects she's identified the defendant in this matter.
Any objection?
No, Your Honor.
Identification is noted.
Thank you. Now, on 5/12 of this year, was there an incident with Mr. Phillips?
Yes.
Was it to the point where police had to get involved? And did that happen at 1227 Mechanic Street?
Yes.
And what can you tell us happened?
Well, that morning I woke up to get my kids ready for school. And I noticed that Jason had either just got home or had been up all night. I was mad. So I went out to the front door to let our cat out and I slammed the door behind me. I walked back to the bedroom and I slammed our bedroom door behind me and I got back to bed. And he comes back in there and opens the door and says, "What is your problem?" And I told him to leave me alone. I yelled. I told him to leave me alone. As soon as he shut the door, I said, "Leave me alone and go smoke some crack." He came back in the bedroom and got right in my face and said, I told you not to talk about me like that in front of my kids. And if you ever do that again, you're going to be sorry. And then he shut the door and went out to the kitchen. I went out to the kitchen and I was like, "Did you really just threaten me?" And he said, "Yeah, I did. I think he threw something across the counter." And he said, "I told you if you ever said anything about me like that in front of my kids, then you'd be sorry."
So you said he threw something across the counter?
Yeah, I think it was like copper dish.
Was it in your direction or just
No,
throwing?
I just chucked it across the counter.
Okay. So from about threatening you, what happened next?
Well, I asked him, I said, "Well, you have such a problem with you saying things that you don't like in front of your kids, but you don't care how they feel about you not spending any time with them or you not, I mean, 'cause that's a big problem that we've had for a long time."
So at some point during this argument, did things get physical?
Yes, he grabbed me by my neck.
Did he apply any pressure?
I used enough pressure to leave a red mark.
So at any point with his hand on your neck, did you Did you feel any difficulty breathing or lightheaded at all?
No, he grabbed me by my neck and kind of almost like shoved me down. And there was a laundry basket right there, so I put my hands in the laundry basket, and kind of tried to push myself back up.
To stop yourself from being down on the floor?
Right, from being either down on the floor or down in the laundry basket or anything like that.
You didn't want his hands on your neck, right? You hadn't gotten physical. He started this getting physical by putting his hands on your neck. So brace up this laundry basket. What happens next?
I get myself up and I stand up straight and I walk right by him and went to the back bedroom and I grabbed my phone.
And at some point, did you call police?
I did.
Do you know if he was arrested that day?
No, he wasn't.
You know if he was arrested shortly after that?
He was arrested Friday night.
The next day?
Friday, yeah.
You know if as a result of being arrested, there was a no contact order put in place? From that first incident, where he wasn't supposed to be contacting you because of a court case?
Yes.
Your Honor, I'd like the court to take judicial notice of the fact of the no contact order that was signed by this court on 5/13 of 22 in file 22-1283 SM D54A.
Okay, so noted.
Just note the fact it was stating he was not to contact Ms. Phillips or be at her residence. In fact, people have what's marked as proposed exhibit 9. If I may approach the witness. Ms. Phillips, what does it say at the top of that document?
Pretrial release order.
And does it have a defendant name on it?
So,
And what is that defendant name?
and Michael Phillips.
And on the second page, do you see if it has a date on it? At the bottom?
13/20/23.
And what does it read leading up to that?
This order shall be entered into lien and effective when signed and expires on May 13th, 2020.
Thank you. Here at this time, people would seek to admit to a proposed exhibit 9. Besides the fact, I believe that it is self-authenticating as the document of this court, and one that the court's already taken judicial notice of.
Any objection?
I guess I'm not certain she can lay the foundation for a document that the court produced. That having been said, I would have stipulated the document. coming in.
Yeah, I don't think she
Or
can lay the foundation either. I don't think it's necessary because we actually have a copy in the file because it was put there appropriately, so I know what document you're talking about.
Oh, fantastic. I wasn't sure if it was put to that one.
Thank you.
All right. So the people's motion to admit this,
He's stipulating, so maybe a minute.
and I would post to the court, but I believe the court already has one.
Thank you.
Now, the next day on 5/13, did you take your kids over to Tonya Wakefield's home?
Yes.
And why did you do that?
Well, he told me I couldn't come back to the house,
Who told you that?
basically,
And when did he tell you that?
because I called the cops. He was mad and basically told me I effed up because I called the cops and I could come get my stuff and I didn't have to leave.
Did he threaten you or say that you just weren't allowed to live there anymore?
He was threatening to throw all my stuff out. So I guess I would basically be saying that I can't stay there.
So were you concerned for your children's safety?
Yes.
And why are you concerned for their safety?
I've never seen this manifest before.
In what way?
He was
erratic in just the threats and the violent behaviors and I mean, I was afraid for myself and my children.
Did you continue to receive messages and phone calls with him between that day of 5/12 and of 5/16?
Yes.
He sent text messages to you? Could you estimate how many ballpark figure?
No.
And
I
why would it be
woke up
difficult?
one morning to 50 overnight.
To 50,
Yeah,
and this
that
happened
was
over the
just
course of,
one night.
this happened over the course of 5 days? And what about phone calls?
Same. I mean, again, I woke up, I want to say it was one of the nights I was staying at Tanya's house. I can't really remember what day it was. But he had called me 108 times
One day,
in one night.
one night?
In one night.
Your Honor, permits me to approach the witness with Wilson Marcus Peoples proposed exhibits 7 and 8. So I'd like you to take a look at these. Do you recognize what's being portrayed in these photos? And what are those showing?
Jason basically threatening me to, he was trying to get me to call the prosecuting attorney's office, to get the charges dropped. And
Those charges being those original domestic violence charges from the 12th.
yes,
And do those appear to be an accurate reflection of the text messages, some of the text messages he was sending you?
yes.
Your Honor, at this time, I would seek to admit People's proposed exhibits 7 and 8.
Have any objections?
No, Your Honor.
7 and 8 are admitted.
Thank you. And permission to publish them.
You may. Thank you.
Now, he was calling you while he was still out of custody, because he had been released from jail, correct? Did he call you while he was in jail?
Yes, he did.
Did you speak with him during those times? Now, did you speak with him from jail during the second time he was arrested on the 14th of that month?
Yeah.
And then did you speak to him again only 4 days ago on 5/30 of this month?
Yes.
And that was while he was in jail.
Yes.
And did he discuss this case
Yes.
and this hearing?
Yes.
And what were the types of things he was saying about the hearing?
He was trying to assure me that I wouldn't get in trouble for not showing up.
Did he tell you not to come to court to testify today?
He did.
And why did he want you not to come to court?
Because if I didn't show up, he thought the charges would be dropped.
Did he say that he was either going to go to prison or go home?
And he was gonna be well, if the charges didn't get dropped, he fears that he's gonna be in prison for a long time.
And was he saying that it was up to you whether he went to prison or not?
Yeah, he said my fate was in your hands.
And you've been with him, married to him for 8 years. You recognize his voice, right? And you were sure it was coming from the jail?
Yes.
How do you know it was coming from the jail?
Because I've already received multiple calls from the jail, and if you don't answer it, it goes to your voicemail, and it'll leave a voicemail that says this call is from an incarcerated, from a facility. It's
So-
basically a
and-
voice message from the jail.
Okay, an automated message?
Yeah.
So did he pick up every time he called you?
No.
How frequently has he been calling you while he's been locked up?
The first few days, it was several times a day. I believe there was one day he had called me 14 times in one day.
And so you're getting messages every time you don't answer the
Yes.
phone?
Over the last couple of days, it's slowed down a lot. The last 2 days, but I think we knew that court was coming, so.
but on the 30th, he was telling you not to come to court. Was he threatening you at all or promising you things? Was he promising things for your children if you were to go home on Friday?
No.
Did he promise you taking to Disney World?
Yes.
Did he say anything along the lines that he wouldn't do this again?
Along those lines, I mean, he talked about wanting to go get counseling and go get help and try to work out our problems.
Did he try saying that if you were released on Friday, he'd come live with you?
He did make a comment about coming to the house on Friday, yes.
And you talked to him about that. Did he tell you to inform the court you were living at your mother's residence so he could live at the house?
He did.
But you wouldn't actually be living at your mother's residence, right?
He told me to say that I had moved, and changed my address, obviously, so he could come back to the house.
So he wouldn't get in trouble for being with you. And that wasn't something you wanted, correct? Now, I know remembering specific days during these 5 days is difficult because of the sheer number of calls and texts as we've already testified to. But first of all, I want to verify your phone number, 517-746-3834, correct?
749-3834.
749. That would be my very poor handwriting. And then for a brief period of time, were you also using the number 517-402-1863 when talking to him in jail? At some point in the calls with him in jail, did he start using the other inmate accounts? Did he say that he was going to call from a different account?
He said he was going to use another inmate's phone number, whatever that means.
Did he say why so he wouldn't get in trouble?
We don't recall him saying that.
That's like I said, I don't remember. Perfectly valid answer to give. At some point, I can't believe I'm saying these words. Did he try and fake his death in the messages to you? How? Can you please explain a little bit about that?
He had a friend of his call me and asked me, well, first he asked me if he had a gun. I believe I told him I don't know, I wasn't sure. His friend told me that they were at the residence on 12 Mechanic, and
That's your residence, right?
that's my residence,
Where he's not supposed to
where
be.
he's not supposed to be. His friend was sitting out in the truck in the driveway, and Jason had went into the house, and I guess he had been in there for a while, and he wasn't sure what was going on, and he was concerned.
Did you receive a photograph?
I did.
And what did that photograph depict?
It showed Jason laying in the bathroom. What looked to me like blood everywhere.
And so, what did you do when you got those messages?
I called 911.
They sent officers out there? Did you end up seeing inside the residence later?
I did.
And what did you see in that bathroom?
It was fake blood.
How do you know it was fake blood?
The bottle. There was a bottle of fake blood left on my dining room table.
And it said it was fake blood?
Fake blood.
Do you know why he did that? Did he say it all in these messages?
I felt like he did it to get me to come to the house. At the time, that's really what I thought, that he thought maybe, I would come rushing over there or something, and what he wanted to do at that point, I don't know. But from my understanding now is he wanted to get my attention. I don't know if it's because I had been ignoring his phone calls. I'm honestly not really sure why somebody would do that.
At that point, have you gotten a personal protection order?
Yes.
You know if it had been served on him yet, or have you not been able to accomplish that yet?
At that time, I don't think it was.
Now, on 5/17 of this year, did you find Mr. Phillips inside your home, the 1227 mechanic?
Yeah.
Can you describe that a little bit for me? What you remember about that?
I think I had just gotten home from work and I drove by the house and I realized that nobody was there. Now, me and the kids have been gone for over a week. You know, we didn't have a whole lot of stuff in the house.
But that was still your residence.
Right. Well, I mean, we hadn't been there because I didn't know when he was gonna show up, if he was gonna show up.
So even though
So
he
we had-
wasn't supposed to be there, you were afraid he was gonna show up.
Right. I noticed that his truck that he drives is not in the driveway. So,
Did he normally park his truck in the driveway?
yeah,
So did you enter the home at that point?
yes, my mother and I and the neighbor, my son was with me. The front door you couldn't get into because I think the city had boarded up the front of the house at that point. So we went around the back door and it was unlocked. Didn't seem like anybody was in there. It was quiet. I mean, and this was early evening hours, so. We're walking through the house and I walk into the back bedroom and he's laying in our bed, wrapped up in a blanket, sleeping.
So what goes through your mind when you see that? What are you feeling in that moment?
I freaked out.
You're afraid?
Yeah.
What
And
were
I
you,
didn't know if he was gonna wake up and see us all standing there over him.
what were you afraid was gonna happen if he were to wake up and see you?
For him to get violent with somebody. I mean, I had other people with me too that I was concerned about.
And this was after you had heard he had broken in the door to
Yes.
Miss Wakefield's home to look for your children?
Yep.
So what did you do?
We walked out the back door that we came in and I called 911. I told them that there was no contact and I gave them a brief rundown of what had been going on over the last 5 days. And that he was supposed to be at the house.
And so did they come and arrest him?
Yes, we did.
And do you know the name of the person who sent you the photograph of him faking his death?
Yeah.
And who is that person?
Gary Newman.
Do you know who that is?
I've known him for a while.
Who is he?
He's a friend of Jason.
Now, with all of these texts and phone calls that were happening over these 5 days, you weren't responding to them, right? Testify to that?
For the majority of them, no, I did not.
No, the two exhibits that were shown, you were no responses in any of it.
Okay, right.
You didn't want these contacts happening, right? And did it make you feel scared to be getting all of this?
Yeah.
Make you feel harassed?
He had made comments about, you know, having people following me around and he knew where I was and he knew where I was staying and he was gonna come find me and the kids. So yeah, when somebody is constantly threatening you and texting you nonstop.
They say he was gonna hire a private investigator. Or did he mention a private investigator following him?
I believe he texted that to Tonya. I'm not sure if he texted that to me.
Okay.
So that I heard of that, that text.
You didn't
It
get
didn't
that
actually come to me though.
Okay. It was clear to him that he didn't want him contacting you.
I think so. I think that's why he was so late, trying to get me so desperately to answer the phone.
Well, you got a PTO during this, right? And to be clear, while he was still out of custody, he sent you text messages having you try and get the police to drop the original domestic violence case, right? That was in people's proposed exhibits 7 and 8.
Yes.
And then separate from that, in phone calls from jail on 5/30 of 22, he was telling you not to come to court, so this case will get dismissed, correct? You know what effect this all has had on your child?
She won't even talk to him.
She angry, scared?
She's scared.
Okay.
Yeah, because she's seen, I tried to keep her away from all of this as much as I could during those 5 days. That's why there was a time when she would be at Tonya's or she was with my mom. But it's impossible when it's a continuous thing going on for 5 days. But she was also at the house, you know, when the original assault happened. She knows that I had called the cops because he had spoken, so. Yeah, I think for a 7-year-old, that's a lot to take in.
One more. This time, people have no further questions, Your Honor.
Be cross-examined.
Very briefly. Just had a couple of follow-up questions, okay? When did you say you left the house? Like what date? Talking about the 1227 Mechanic Street.
So after the first assault,
Yes, ma'am.
well, it happened in the morning. I went to work that day. And then that night, we stayed at Texas.
You were there, you said, for a couple of weeks or a week?
We were there up until, I think it was the 19th, it was a Saturday. It was the 19th Saturday.
And from there, where did you go?
We stayed at a hotel.
And so, just to be clear, what was the day that you came home and found my client sleep?
It was a Tuesday.
It was in
I
that
had a
window?
calendar in front of me. I could show you the exact date. It's hard to keep the days and the dates together when so much happened over such a short period of time.
And that, the 1227 Mechanic Street, that's the house my client inherited from his grandma?
Yes.
You two were married for 8 years, you said?
Yes.
Were you together before that?
Yes.
So you've known him for
10 years.
roughly 10 years? You said this was the first time this had kind of occurred, is this couple of weeks leading up to the, you calling it as he grabbed you and pushed you down.
To that extent, yes.
You know if he takes medication?
He does.
Is it, I'm gonna say this as best I can. Wanzapin or Seroquel?
He is supposed to take it. It's not.
And that's for his schizophrenia? He wasn't taking it at this date. You were gonna bring that to the jail for him, you didn't? Is that true?
Yes.
Let me break that into 2 questions. You were going to bring it to the jail for him, correct?
Well, I or somebody else, whoever he wanted to have come grab his belongings, I was going to offer either myself or his mother to take his medication up there if he needed it.
And his schizophrenia medication has not been delivered to the jail yet, that's your knowledge. You still have it.
Yes.
This whole time he's been in jail now, to the best of your knowledge, he's not taking his antipsychotics.
Yes. I don't know if I do it to him. I don't know what he's taking now.
He told you couldn't live at his house anymore? 1227 Mechanic? That's what you testified to on direct.
He threatened to kick me out.
And then you left.
Yes.
Do you know approximately how many weeks from the date that you went to work, came home and left until you decided to move back in with? Well, how long a time period?
We had to take a few days to get the house cleaned up because they destroyed it. And I had to get the front door fixed. There was no handle or deadbolt on the front door. That's why the city boarded up the front door. And then the back door had a lock on it, but I didn't have a key, so I can't take my kids to a house that is trash. I mean, with pictures of it, and see everything else in my yard and isn't secure. So,
You moved out for about 2 weeks, maybe?
maybe a little less. This whole incident took 5 days, and then it took a few days to get the house cleaned up and secure.
But you moved back in after he was sent back to the jail, is that correct?
Yes.
Do you have a custody order in place
Yes.
with Jason and your daughter?
Yes.
Did you have it in place on the date of any of this stuff before he was sent back to jail?
It was done back in 2019, I believe. I was unsure of it until I went down to the PPO. Provided me with a piece of paper that showed that there had been custody.
Between you and Jason for, I'm gonna butcher her name, Adriana?
Yeah,
That custody order is still in place despite being married?
yeah. It just states that I have physical custody, but we both have legal joint.
Is that from a prior separation or something?
I'm not really sure. I don't even remember going down and getting. When I went down to go get the PPO, she was like, oh, there's already a custody. And it was back in 2017.
You don't remember filing any sort of complaint for custody or anything like that?
No.
You were married at that time and living together, correct?
Yeah.
Do you remember going to any sort of thing called a conciliation or anything? Like a meeting at the front of the court where you sat down with an investigator and talked?
No.
You sure it's not in regards to your older child? Very much.
One moment.
Just to give you a.
How long have you been living at the 1227 Mechanic Street? 6 years you've been with Jason. That's the only home you've had? The only home you have?
She nodded.
Yes.
Thank you. And thank you. People have no further questions at this time, Your Honor.
I just want to clarify timeline. They were married for 8 years though, correct, ma'am?
Yes.
You married when he inherited the house?
Yes.
Okay. Any reader cross based on that?
None, Your Honor.
You can be excused. Call your next witness.
People have no further witnesses, Your Honor. Everything that's been needed has been met in this case.
Any stuff that you, okay. Will the defense be, I just wanted to make sure you didn't have a bag or anything.
Oh,
that you
yeah, I
left.
think her
Okay,
was done.
okay. Any witnesses from from the defense?
Not today, Your Honor. Thank you.
You can proceed to argument.
Your Honor, I'm going to take these one at a time. So the first case I'd like to address is that of the home invasion 221286. That is charged with home invasion in the first degree of 1124 Bench Street. We heard from Tonya and Trinity Wakefield about the damage that was caused to that property. The fact that Mr. Phillips had no right to be at that property while after he broke his way in, damaged the front door, as shown in those photographs. He assaulted an individual who was legally present inside that home, Trinity Wakefield, a 15-year-old girl, shoved her into the wall. And Your Honor, all of the elements have been met for a count of home invasion in the first degree. Additionally, the people will be requesting an added misdemeanor count of malicious use of a telecommunications services. The PAC code for that is 750.540E as an elephant, as he was maliciously used the phone to threaten bodily harm, murder against Tonya Wakefield. And then I request an added count 3 of assault and battery, PAC code 750.81 for Trinity Wakefield. As she testified to, he shoved her into the wall. He had no legal right to do it, no legal right to be there, and she did not want to have his hands be put on top of her. So I believe that elements have been met for all 3 of those counts. I'd ask that we bind over as such. Now, for the other case, more complicated matter, 221316. He's charged with, as charged, it's 1 count of aggravated stalking, and that has been clearly met here. There is no contact order put in place on the 13th, as the court's taken judicial notice of. He would not contact her. He contacted her hundreds of times, by text, by phone, even while he's been locked up in our jail, threatening her, demanding see her children, faking his own death. As she said, they were terrified, scared. She felt like she was being harassed. She didn't feel safe going back to her own home that she legally had the right to be there. I want to address this point now. It does not matter that she did not immediately go back there. The no contact order states he is not allowed to be at the home, school, or work of Rachel Phillips. That does not mean where she is currently staying the night in that moment. 1227 Mechanic was her home, has been her home, her only home for 6 years, and he had no legal right to be there per this court's order. They flagrantly violated that. The fact that he terrorized her to the point where she did not feel safe returning to her own home does not give him a legal right to be there. It does not mean that now he can get around the no contact order by scaring her where she felt like her kids were in danger. Which is why the people will be requesting an added count 2 of home invasion in the 2nd degree. PAC code being 750.110 A is an apple 3. As the defendant entered without permission 1227 Mechanic Street and did so with the intent to commit the crime of aggravated stalking, which is a felony therein. The fact that she is not home is the only reason it was not. I'm not requesting home invasion in the 1st degree. Next, people are requesting an added count 3 of interfering with a crime report by committing a crime. The PAC code being, this is a long one, 750.483 A is in apple, 2 B is in boy. Under the specific theory that the defendant retaliated, attempted to retaliate, or threatened to retaliate against another person, that being Rachel Phillips, for having reported a crime committed by another person, being him, by threatening to cause property damage. Which I didn't consider until she was testifying here today and testified that because she called the police, had him charged, had him locked up, who's harassing her, threatening to destroy her property, to trash her things, which I believe is actually evidenced in People's Exhibits 7 and 8. Said something to the effect that it's trash night, all your stuff is going to be trash. So I believe that there has been sufficient evidence for that. The people will then be requesting an added count 4 of witness interference. Act code being 750.1227A. And I'll be requesting 2 counts of that, 4 and 5. 4, the time frame being on or about 5/30/22. And for add count 5, the time frame being between 5/13/22 and 5/16/22. Count 4, she testified that he called her from jail 3 days ago. Told her, don't come to court today. You don't come to court, it gets dropped. Don't come to court so I don't go to prison. That's clear witness interference, Your Honor. And then, as is evidenced in those text messages, in People's Exhibits 7 and 8, he told her to contact the police, say that it didn't happen. She was just angry to get this all dropped, get the no contact order dropped. 2 separate incidents of witness interference for 2 separate cases. Well, technically, every time he did so is a new kind of witness interference. My office doesn't like to charge in that regard. But these were clearly separate times, separate means of interfering, and try and get separate cases dismissed. So I'm asking requesting an add count 4 and 5 of witness interference. And then, lastly, an added misdemeanor count 6, domestic violence, 750.812. The date being on or about 5/12/22. Now, this is the case that is this is the offense that is currently charged in the misdemeanor file. That file being 22-1283 SM-D54A. I've spoken about this with defense counsel earlier as to my intention. The intention, given how interlinked these are, and how interlinked they have now become because of defendant's own actions in trying to get them dismissed, that the misdemeanor charge that she testified to and laid the elements out for be added to the felony case, then the people will be filing a nollie cross after the PA3 hearing in that matter. So there will be no double dipping, but it will be handled in the one file of the circuit court.
Can you give me your added count 3 again?
Absolutely. Added count 3 is interference with the crime report by committing a crime. Pack code 750.483A2B. And it is under the theory that admittedly I do not frequently use because I do not frequently have a reason to do so, that he did retaliate, attempt to retaliate, or threaten to retaliate against another person for having reported or attempted to report a crime committed or attempted by another person by threatening to cause property damage. And she testified that because she had called the cops on the 5/12 incident, had him arrested, that he was threatening to destroy her property. That is clear retaliation for having reported a crime. And do so by causing property damage. And even specified in the text messages that were in Exhibits 7 and 8 that he was going to destroy her things.
You wanted added count 2 of home invasion 2nd degree, you said?
Yes. Added count 2 of home invasion 2nd degree. Added count 3 interfering with a crime report by committing a crime. Add count 4 witness interference with the time frame being 5/30/22. Add count 5 of witness interference with the time frame being 5/13 to 5/16. In fact, that was during those days where he was constantly texting and harassing him. And then the misdemeanor domestic violence for count 6.
Okay, thank you. Mr. Crunch.
Your Honor, the defense is aware it's a preliminary examination and the burden upon the court. Certainly, I don't think, well, at least the defense and perhaps not the prosecution is expecting her to talk about an existing custody order that she's never heard of, didn't file for, never attended a meeting for at the front of the court. So that's something we're going to have to investigate further ourselves. But I think that there is, at least as far as the Wakefield home invasion count, an issue in regards to the fact that a man came to the door seeking his children, and the statement from the witness mess up her name, Trinity, was that you said? Was that she grabbed his daughter and took her and hid her, then stood in the doorway and prevented him from getting his own child. And I don't know what gives her the legal justification to basically hold his daughter against a parent's will. Well, I think that would give rise to allowing an individual to come into your house to retrieve their child. If the kid is being held against the will of a parent.
So you said that there was some law that allows you to enter someone else's house and retrieve your kids? Is that what you said?
If somebody is holding your kid against your will, I think that you would have a defense to going to get your child back from
Well, if
somebody.
that was the case, we don't have such facts before the court.
Certainly not. Other than that, I guess I would leave it in the court's discretion. Thank you.
Thank you. Today's the date that was set for preliminary examination. The burden today, Mr. Phillips, is on the prosecution, and they have to establish sufficient facts that a crime was committed to a probable cause standard, and also that there's sufficient probable cause to charge you with the crime. This is a relatively flexible burden. It's based on common sense and facts and evidence presented today at the hearing. It is a burden that is much lower than any burden that you would face if you were to go to trial. The burden of trial is going to be beyond a reasonable doubt. This is probable cause, which is more than mere suspicion. I'm not going to recant or rehash all of the testimony, but I will indicate that in file number ending in 1286, we did have testimony today from Tonya Wakefield and Trinity Wakefield. They gave testimony that on 5/13/2022 at the area of 1124 Bank Street, which is located in the city of Lansing, Ingham County, state of Michigan, that the person that they identified as the defendant, Mr. Jason Michael Phillips, appeared to the property, caused damage to the door of Miss Wakefield, Miss Tonya Wakefield, who owns that property, and entered the property. Trinity testified that she took the daughter, or the young, I think she referred to her as little girl or young girl. She took her to the basement because she was fearful or afraid of the interaction. She testified that the defendant pushed her up against the wall by using his, I believe she motioned towards her right arm, but she was unsure as to which arm he pushed her with, but he was screaming at the time, "Where are my kids?" The people admitted exhibits 3, 4, 5, and 6, which are photographs of the front door lock, which are or appear to be broken and damaged. The front door hinge appears to also have been damaged. There was testimony from Miss Tonya Wakefield that she received threatening text messages from a number that she associates or has saved in her phone as not pronounced or spelled N-U-T-T, but she said that's the nickname that she uses for Mr. Phillips. And then these text messages, she said that she's also received phone calls around the same time frame, indicating much of the same content, but there is a text message included on People's Exhibit 1, in which the person identified as that, which was the number that was saved in Ms. Wakefield's phone for Mr. Phillips, says, I'm blowing your fucking brains out. Where's my kid? So based on the testimony here, and the exhibit, the evidence entered, the court is satisfied that there is sufficient probable cause as to count 1, home invasion in the first degree. That will be bound over to the circuit court. The people are requesting to add count 2 of malicious use of a telecommunications device. The court will grant the request to add a count 2. And that will be bound over based on the evidence submitted here in People's Exhibit 2. And as to the request to add a count of assault and battery against Trinity Wakefield, that's a misdemeanor that will be granted, and that will be bound over along with the count 1 and count 2. Now file number ending in 1316. There was testimony today from Ms. Rachel Phillips, who indicates she is the wife of Mr. Phillips. Stated that she resides at the area of 1227 Mechanics in Lansing, Michigan, and she gave a host of information and testimony about interactions that expanded over a time period of about what she said was 5 days, but would have taken place beginning on or about May 16th through 17th, but after there had been a no contact order or PA 53 in place by the court took judicial notice of the PA 53. There was an order signed by Magistrate Cindy Faulkner, which indicated that Mr. Phillips was not to have communication directly or indirectly with Rachel Phillips, not to be within 1,500 feet of wherever she lives, works, or goes to school. He was allowed to go one time with a peace officer to that residence only for the purposes of removing personal items. He also was not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in other conduct that would place Rachel Phillips or a child of Rachel Phillips in reasonable fear of bodily injury. Therefore, based on the information presented via testimony as well as exhibits entered by the people in exhibits 7 and 8, court is satisfied that there's sufficient probable cause to bind over as to count 1, stalking aggravated. The people are requesting to add a count 2 of home invasion, 2nd degree. I'm going to deny that request. Doesn't sit well with me because he is a homeowner there. There's a no contact order, but that doesn't absolve him from being a homeowner. I just think it gets messy and we start trying to have home invasion with someone who owns the home, or is at least owning it with their spouse. As to count 3, there's a request to add for interfering with a crime report by committed a crime. Based on the testimony presented today, the court will grant that request and add count. Well, it'll be count 2 because I'm going to deny your request for the added count 2. So it'll be added count 2 of interfering with a crime report by committed a crime. There's a request for an added count of witness interference as of the date of May 30th, 2022. And witness interference as of the dates of May 13th through May 16th. That date frame correct?
Yes.
Okay. The court will grant your request and add counts 3 and 4 of witness interference based on the testimony evidence provided today. Lastly, there was a request to add a count of domestic violence for May 12, 2022, which is the subject of a pending misdemeanor charge that has a PA 53 associated. That matter is set for PA 53 hearing. The court will grant your request to add that for the purposes of linking that with these transactions, and we will address the domestic violence or nulling of the other domestic violence pending on the misdemeanor file at the time of the PA 53 here. So your bind over date, sir, is going to be June 15th. You do not need to appear in court on June 15th. That's the date that they're going to get the file from this court. You will not have an arraignment in the circuit court unless your attorney makes a motion to the circuit court indicating why you would need to be arraigned before the circuit court. Your next court date will be a pretrial in the circuit court. Mr. Cornish will be provided that date and he'll be in contact with you, okay? Okay. Do you have any questions, sir? Additional matters for the record.
I want his phone privileges taken away, Your Honor. She testified he's been calling her from jail multiple times and multiple different times he was in jail.
I have here, bond was set on May 27th by me. I could not set his bond on the 18th, which is when I believe I was in rain. I have a note here that he became disruptive. I had to remand him at the time. I addressed his bond as PCC and I set it at $50,000 cash surety with GPS tether and victim notification. There was testimony today about multiple calls from the jail to the victim in this matter. I'm not sure, but I'm sure Mr. Piper knows the approximate amount of calls. I will make a determination if there's been an abuse of phone privileges, and I will grant your request to restrict his phone privileges.
For the record, 65.
Any additional matters for the record?
Not for the people, Your Honor.
Not today, Your Honor. Thank you.
Thank you. Off the record.